Review petition?
Yes.
It has been filed on 16th May 2025. And your lordship's last order was passed on 5th August 2025.
In the review?
No, to comply with the order to give a copy of the canned application to other side. That has been complied.
We have placed an order.
Yes.
It's on notice to the other side. That has been complied.
So review was taken up?
No, not taken up. Not yet taken up.
And how we have passed an order?
Your lordship passed the order to supply the can to other side. Yes, sir. That is the only order passed, my lord.
So it was taken up. That's what we are asking you. That means it was taken up. Very well listed. Next week listed.
Number 3.
Your Lordship, I'm praying for withdrawal. Your Lordship, this is the written instruction of the petitioners.
And I appear on behalf of respondent numbers 1 and 2.
Yes, to be sir.
Litigos and joint Ghosh.
And another. Who is the other petitioner?
Your Lordship, one is Aditi Ghosh and the other is your Jointo Ghosh.
Who is he? Your
Aditi Ghosh and Jointo Ghosh, Your Lordship, they are husband and wife.
an application.
Now 4.
Lordship, I beg to appear for the appellant, Your Lordship. Lordship, we filed this appeal against an order dated February 26, 2026. After filing the appeal, Your Lordships have passed an order dated 21st May.
Yes, we have been passing that order in all the cases to avail the remedy. Of the OA also. Pending OA is number?
OA number 371, Your Lordship.
Taken
371 of 2025. Your Lordship, I would be seeking one.
OA number 371 of 25 is also disposed of. Otherwise, he cannot approach the writ court. Yes.
Your Lordship, I would seek one liberty. If liberty may be given for us to file a writ petition.
Yes. That we are giving in all the orders. To file a writ petition before the single judge. To facilitate consideration, we are disposing of the OA because both cannot proceed parallelly.
Your Lordship, as Your Lordship, so please, if
we have been passing that order in every case. Because the OA cannot be kept pending and the writ court cannot consider, both cannot proceed parallelly.
Your Lordship.
You are required to approach the writ court, so we are disposing of the OA and you cannot withdraw because tribunal is not available.
It is not available.
So therefore, we have been disposing of.
Lordship, we filed this writ petition WPA because the tribunal was not functional. We had filed that
Understood. So then the court said you go before the tribunal.
Your Lordship kindly takes the impugned order.
What is it? Tell us.
Lordship, the WPA was dismissed, wherein his Lordship was pleased to hold that we should have approached the Honorable Division Bench.
Division bench.
Your Lordship.
So that order is under challenge, not tribunal's order.
No, Your Lordship.
Oh.
The order of the Honorable Single Bench, Your Lordship.
Hmm. Yes.
Official method.
That order we have passed in WPST 209.
209 and 2010. Your Lordship, I have a copy of the orders.
The admitted position
Your Lordship, the matter was taken up by the learned tribunal on July 11, July 22, and July 24. We filed an application.
OA is of which year?
OAs of 2025, Your Lordship. It was taken up on 3 occasions, twice by the registrar for the initial order and
No, is it prior to September or subsequent to September 25?
prior to September, Your Lordship. The tribunal was functional when we filed the original application. Subsequent thereto, the tribunal
So
became
then why you have challenged the single judge order?
Lordship, because the tribunal was non-functional, it was my understanding that a writ petition would be lying before the honorable single bench. Therefore, we filed that, and that was dismissed. So we are in appeal against that learned honorable single bench's order, single judge's order.
Even after reading this judgment?
Your Lordship, after this appeal was filed, this judgment was delivered by your Lordship.
So therefore, we are asking you today what remains in the order of the single judge. How can you be aggrieved by that order if this is the law we have stated in the division bench? What do you want to be done with the single judge order? You tell us. It should be set aside.
Your Lordship, I'm praying with your Lordship if this mandamus appeal, has become infructuous, in my understanding, Your
Yes.
Lordship, this mandamus appeal has become infructuous. So,
Yes.
and I would be seeking your Lordship's liberty to file a writ petition state tribunal WPST before your Lordships against because the tribunal.
But that liberty is already granted to you in paragraph 9 of the Honorable Single Judge Order. Please read paragraph 9.
Your Lordship.
Then what remains? What does it say, paragraph 9? The order shall not preclude the petitioner from taking steps in accordance with law.
Your Lordship.
So where is the requirement of us saying anything? In view of the decision of this court, All right, if you can't understand, we can't help you.
Order 5,
For the petition. Service complete though. But affidavit of service copy of service.
সার্ভিস মানে
হ্যাঁ, service
ইলেকশনের আগে
আচ্ছা অফিসটা কবে হয়েছে
Shall we go before the single judge bench?
এটা
We'll have to go before the single judge bench.
well, because it is a WPST and there is a prior proceeding pending before the administrative tribunal blood. Although we are not in appeal because there is no order impugned, the tribunal is not functioning, there is no judge Millard. It's vacant.
You have seen WPST 209.
But I will, if Lordship wants, I can consider and I can consider that. I have not considered whether Millard.
It is just there in the earlier case. Give him that 209 judge.
Lordship feels it should be before the single judge.
We have already decided if the matter is filed prior to becoming the tribunal becoming non-functional, WPST. After becoming non-functional, you cannot be left remedialess, you approach the writ court.
Because the that right. Oh, that is a settled
So we have decided that in this case,
I will take down that.
please take it down, we will dispose it off. We will record that you will avail the remedy before the honorable single judge and you will give an undertaking that you will withdraw the original application. Being faced with decision of this court.
order 6,
I am for the
লর্ডশিপ item number 6 লর্ডশিপ the disciplinary proceedings file was to be produced lordship they've left but they are called they haven't arrived as yet lordship
Not today will do.
they're not today lordship but yeah. ঠিক আছে
order 7,
My lord, I am for the petitioner. Initially, Mr. Tapun Mukherjee was appeared, but I have made inquiry. Till now, no one has been engaged. My lord, kindly give us some direction so that state can engage any state advocate. Otherwise,
আমাকে দিয়ে দিন 20 তো
7.
হ্যাঁ মানে 2020
The learned advocate for can prepare herself, otherwise unnecessarily.
I should have solved
Yes.
something. I mean,
হ্যাঁ ঠিক আছে ঠিক আছে দাঁড়ান দাঁড়ান
order 8,
একে দিয়ে দে Lordship Papun Ghosh, I appear for the state lordship. Huh? Lordship, the writ petition, the learned advocate for the writ petitioner, I believe is engaged in court number 36, Lordship. That is mean.
He is mentioning before a division bench that he is appearing.
I know, Lordship, that is what that is been sent word. It's It's very unfortunate, Lordship, that is why.
Last day there is no peer.
That is the thing. Yes.
Item 9,
Item 9, Lordship, I am appearing for the.
Yes.
Last occasion, your Lordship asked the report from the.
Yes,
respondent.
Lordship, this is. This is the inquiry report, Lordship.
Any legal errors? Are
Lordship,
there any legal errors?
I'll just check, Lordship. I'm
Just now
handing
you
over.
got the report.
I just got
Go
it,
through
Lord.
it,
I'll,
not put it.
Lordship.
Can let him also have a.
I'll have, give him a copy, he can go through it also. Have a take. Put it up. Put it up to date.
item 10,
Not to date.
In Lordship, I am for the petitioner. This matter relates to higher pay scale of the West Bengal ITI Staff Association, the ITI teachers, Lordship. The Lordship, by an order of this Honorable Court by Justice Altamas Kobir, the staffs of the West Bengal ITI was granted the post of teachers, Lordship. Before that, they were treated as non-teaching staff,
What is the date of the OAs of 2016?
Lordship.
And what you are doing for 9 years?
Lordship, matter was being heard and now the administrative,
Matter was being heard.
now the administrative tribunal was, and there was an earlier direction by this Honorable Court, Lordship kindly sees the page number 135 and 136. The petitioners approached before this Honorable Court for expeditious disposal of the said matter. The matter was heard and order was passed on 24th of September. Lordship, it was in 2021. Till date, the matter has not been disposed of and now the tribunal is not working, Lordship.
Where is your OA?
Lordship, in the supplementary affidavit I have filed, Lordship.
Page, please.
It starts from page 3. The entire OA is annexed, Lordship. ये कॉपीটা annex করতে বলবো যে reply করছে reply এর কপি কি আছে reply এর কপি আছে তাহলে সেটা আপনি তাহলে Lordship, we have approached this court by an in light of the Supreme Court's order dated in 2001, Lordship, reported in AIR 2001 Supreme Court, Lordship, that order I have annexed in the OA also and also in the writ petition. It starts from number 41 of the OA. আমার আমার order ছিল
Where is the Principal Secretary's order 24/4/2015?
in OA.
Where is the Principal Secretary's order of 24/4/2015?
24th April 2015, it starts from page 101. Reasoned order of the
From 94.
না ওটা রিট পিটিশনে আপনি ওয়েটায় যান সাপ্লিমেন্টারি অ্যাফিডেভিটে 101.
Yes, what is wrong with this order?
Lordship, the Honorable Supreme Court's order, Lordship, kindly comes to, which starts from page 40 of the, page 41 of the OA, Lordship. It's,
No, SC order comes after the High Court order. Where is the High Court order?
Lordship,
The SC order affirms the High Court order.
Lordship, it has stated that the teaching staff,
The SC order affirms the High Court order.
Lordship,
So where is the High Court order?
High Court order passed by Justice Altamas Kabir.
We don't know. Which is the order you had appealed against before the apex court? The Supreme Court has passed an order considering an order passed by the High Court.
Lordship, not in this case, in another case, Lordship, we have annexed.
But in your case also, High Court has passed an order.
High Court has passed and Justice Tapobrata Chakraborty has passed an order, Lordship. I have
That
annexed.
was for consideration. Otherwise, there is no order dealing with the claim of similarly situated persons.
So the similarly situated persons order, we have come after the order passed by the Honorable SC Lordship in Anil Ratan Sarkar's case.
Huh?
Lordship, page 41, it starts from the Supreme Court's order. In Anil Ratan Sarkar, it specifically mandates that teaching staffs will not be paid as per same as the non-teaching staffs, Lordship.
Who can dispute this?
Lordship.
Who can dispute that teaching staff will not get the same as non-teaching staff? For that, you don't need a judgment.
Lordship.
That can be accepted merely for the submission. The point is, are you a teaching staff?
Yes,
Are
Lordship.
you possessing the requisite qualification,
Yes,
which
Lordship.
is being possessed by those who are imparting education in graduate
Lordship,
schools?
kindly comes to page.
Therefore, we ask you what is wrong with the order. You are saying, see the Supreme Court judgment.
Lordship, it comes to status is 31 as the government.
You are diploma holders.
Lordship.
You are diploma holders. You are imparting. You are instructors in ITI.
Yes.
You are claiming parity with teachers in a graduate level college. That is the whole thing.
Lordship, page kindly comes to page 31 of the writ petition, Lordship, once. The
Sir,
government order.
the
Government order that change of status of the non-teaching staffs into teaching staffs.
see, there is an order of the High Court. We don't know why you are not showing it. Directing conferment of teaching status on these instructors. Where is that order?
Lordship, Justice Altamas Kabir's order. It is annexed.
You have relied upon that in your before the principal secretary. Which page?
108.
Lordship, it starts from page 37.
37.
Justice D.K. Basu's. Seven of the OA, supplementary affidavit.
So this judgment covers you also. Then,
By this judgment, my age of retirement has also been increased from
so you have got that benefit.
Lordship.
Then what else does the
Pay
judge,
scale, Lordship.
where does this judgment say to give a higher pay scale? Read from this judgment.
Lordship, after that the Supreme Court order referring to Lordship.
Yeah.
Kindly comes to page 46, paragraph number 19, Lordship.
No, no, this is not for ITI. This is for government colleges. How this will apply to you?
My status has been changed to teacher, Lordship.
Wonderful. How this judgment applies to you? You are relying upon Supreme Court judgment. This is for the petitioners therein. You read paragraph 3. This will not apply to you. Will not apply. For government college teacher.
Lordship, may I come back?
What come back? We have heard you for so long. Now you want to come back? See, there is a judgment covers you.
Lordship.
That judgment says to treat you as teaching employees. Treat you for the purpose of retirement age. That benefit has been given to you. The judgment, the benefit of which you have taken, says that those who have retired, they should be giving all arrears wages of the enhanced age in the existing scale of pay. The specific direction in your case is in the existing scale. Now you say, I want a higher scale. How can you get it?
Lordship, may I come back 1 week's time? Lordship, kindly fix this matter any day, Lordship. I will.
What is wrong with today? File your opposition, we'll see. You are appearing
My lord, there is a reply filed in the tribunal itself
already.
already, but they have not.
As
sought-
read.
I will. Pro-
29. Grateful.
Item 11.
My lord, I appeal for the petitioner. My lord, I'm filing the opposition reply. Well, copies have already been served. Now, my lord, this is a case of the petitioner is this, my lord. The petitioner before Lordship, my lord, was working as assistant director in the horticulture department. Now, my lord, the recruitment, my lord, as he was working as assistant director, 2 posts of deputy director fell vacant. Now, my lord, a gradation list was published wherein my name is.
You are for?
My lord, I am for the public service. My lord, where.
Have a seat.
My lord, the final gradation list was published. My name is appearing at serial number 3, and the private respondent's name is appearing at serial number 4. My lord, the 2 vacancy arose for the post of deputy director. My lord, what I find that superseding me, my junior were given promotion to the deputy director. My lord, on 27th.
It was merit-based promotion.
Yes, my lord, I may say ACRs, there is no question. My lord, I will come later, my lord. On 7/6/2024, he was granted the promotion. I do not know why I am being excluded. My lord, I made a representation. Thereafter, I appealed to the Learned Tribunal. My lord, in the year 2024 itself, seeking that I am being superseded by my juniors, and I should be accommodated and promoted to the post of deputy director. Now, my lord, during pendency of this, my lord,
You have been superseded by Mr. Layak.
my lord, the private respondent. Now, my lord, on my lord, 5th of May, my lord, this promotion was given on 27th June 2024. 5th of May, my lord, I have received a charge memo. 5th of May 2025, after nearly 1 year, I received a charge memo stating, my lord, under Rule 10, one proceeding has been drawn. Now, my lord, I brought that thing before the learned tribunal by means of a supplementary application that this was there. Now, my lord, after the tribunal became non-functional, my lord, I had no opportunity. I have to approach your lordship. Now, my lord, they filed opposition. From the opposition, what I gather is this, my lord, they have stated that when they send the names to the PSC, my lord, it's a PSC's recommendation is required for the post is concerned, for the promotional post. When they send the name to the PSC, my lord, they have mentioned that there is a departmental proceeding pending against me. The fact remains, my lord, promotions were given on 27/6/2024. Charge memo was issued on 5th of May 2025. And in the opposition, my lord, they have clearly stated while sending the names to the, my lord, Public Service Commission, that departmental proceeding is pending against me. That is absolutely untrue, man. I may say, my lord, it's a lie, I may say, if your lordship allows me to say. Now, if your lordship takes up, my lord, the opposition that they have filed. But before that, my lord, your lordship, can it takes up the promotional order once?
Yes.
But the promotional order is at page 64. 64, that's it. But 56, 56. My lord, your lordship will find dated 27th of June 2024. Now, my lord, there are two persons who were given promotion. One is Prokashing. He is senior to me. I have no grievance against that person. I neither have grievance against this person even, but he has superseded. The next person, Shamantolayak. Now, my lord, if your lordship takes up the gradation list once, my lord, the gradation list was published page 51. 52 would be relevant. 52, my lord. But if your lordship takes up page 52, it's a gradation list. My lord, my name is appearing at serial number 3. Lordship has got it, man.
Yes.
And private respondent's name is appearing at serial number 4. Who got the promotion? Shamantulayak, serial number 4. That's page 52. But two persons got the promotion. Serial number 2 got the promotion. He's senior to me. I have no qualms against that person. My lord, this serial number 4, Shamantolayak, he got the promotion superseding me. My lord, this is my contention before the learned tribunal. Now, my lord, if your lordship takes up the charge memo, which has been, my lord, brought to the notice of the tribunal by means of a supplementary application, page 71.
How you are placed above him, we don't know. His date of joining is prior to you.
My lord, it's basically, my lord, the gradation list, lordship showing gradation list.
No, yes, please see serial 4, his date of joining is 27/11/2002.
Yes, my lord.
29.
You are after him on 29/11/2000.
My lord, it is based on the merit list of the PSC. My lord, it's a PSC merit list, that it's a PSC post.
So the merit list determines the seniority, not the date of joining.
Not the date of joining, my lord. Your lordship will. My lord, I'm senior to that in terms of this gradation list. Your lordship's in the promotional order. Now, your lordship can turns up to page 71. But this is after filing the original application. This was served upon me. I had to file a supplementary application. But page 71 is the, my lord, the charge memo. My lord, dated 5th of May 2025.
Yes.
So my contention is this, my lord, and your lordship knows, my lord, in terms of, my lord, KV Janakiraman, my lord, and subsequent judgment, even your lordship's judgment, my lord. My lord, promotion could not be withheld, my lord, only because in contemplation of a departmental proceeding. But I may say it was done in contemplation, as well as promotion was given in 2024 and a charge memo was in 2025. But my lord, your lordship will find when the names were sent to the PSC, my lord, your lordship can takes up, my lord, the opposition that they have filed. My lord, if your lordship takes up opposition at page, my lord, 19, my lord, it starts from page 18. It starts from page 17. My lord, the additional secretary to the government of West Bengal sending the, my lord, the requisites and the names of, my lord, to the PSC. But she was got in, my lord, in the opposition.
Page
17, R7. of the opposition that they have filed. Now, your lordship will find promotion to the post of Deputy Director of Horticulture from confirmed Assistant Director of Horticulture in the District Directorate of Horticulture under the Administrative Control Department of FPI, Food Processing and Industries and Horticulture. Now, my lord, your lordship kindly turns to my lord, page 19. My lord, this is the list, Annex Check 2, where the names of the officers were given. My lord, your lordship will find at the bottom, my lord, my name is there. Dr. Ronojoy Dotto, my lord, my date of birth, my date thereafter, my lord, date of appointment to the feeder post, confirmation, whether I'm temporary confirmation, my lord, date of confirmation and entry to the post. Or initially it was under the agriculture
So
department.
where is this vigilance department's letter of 28/2/24?
My lord, 28 to my lord. But your lordship will find it says pending. That is the reason, my lord, PSC has not considered my name. And your lord, I will come to that, my lord. Your lordship also find, my lord, page at 23 R8.
23 is R8.
Well, as because it was been mentioned, vigilance proceedings pending, my lord, what the PSC did, my lord, that is apparent. My lord, it's a letter dated 3rd of June 2024. My lord, your lordship will find the second column. Commission did not find the following officers suitable for promotion. Name Gautam Rai to my name. Like if it has been written to the PSC, proceeding is pending, the PSC would have done this, my lord. And your lordship will find, your lordship will see, it says there is a departmental proceeding pending against Dr. Dotto.
Which page?
Page 19, my lord, 19. Well, this is sent by the department. There is an officer of the department.
Therefore, we are asking where is this commission's letter of 28/2/24?
I'm just coming, my lord.
They have enclosed
My
the
lord, your
copy.
lordship will find page 16. Page 16.
Page 16. 16. Integrity clearance report.
Right. It also says proceeding is pending. This is done by the vigilance. It says against 7, my lord, no proceeding is pending. Subject noted above, they said that there no departmental proceeding against seven officers in the Directorate of Horticulture under the administrative control of Department of FPI, excluding Gautam Rai, Assistant Director of Agriculture, Horticulture, Dr. Ronojoy Dotto, Assistant Director of Horticulture, and Atanu Kumar Gupta, Assistant Director of Horticulture, as per available records. My lord, your lordship knows, my lord, the law is pretty settled, my lord.
Where is the charge memo?
The charge memo is page 71.
No. They are referring to some pending proceeding against you. That means charge memo has to be prior to this 28/2/24.
But there is nothing, my lord. Nothing has been served upon me.
Therefore, we are asking. Let us see.
Lordship 20 to 20. If your lordship comes to page 15, the prior annex to R5.
Yes.
This is the information seeking documents of the following officers. So this was from the Joint Secretary. So this was 20th of February, and lordship prior to that is the vigilance inquiry. Lordship comes to page 11, annex to R2. This is 26th of June 2023. Secret vigilance and inquiry, lordship, which I would like to say to the this is from the Chief Secretary to the police. With reference to the above, I would like to say that the Directorate of Horticulture is the implementing agency for distribution of various benefits to the eligible beneficiaries as per requisition submitted by the District Horticultural Officer. Of 50% financial assistance for the beneficiaries for purchase of knapsack battery sprayer 16 liters under the RKBY scheme is one such scheme. Necessary information with relevant documents as asked for by the State Vigilance Commission is given below for perusal. The implementation of projects under RKBY was entrusted to the Director of Horticulture as per available record. On the basis of a discussion with the MD, so-and-so, and the then Director of Horticulture admin, as per rate offered by the MD Munjusha, by their reference number so-and-so dated 17th of 12/2022 was selected directly to apply to ASPI make knapsack battery spare 16 liters with their order dated 16th of 12/2022. As per available record, none. It was ascertained subsequently that no expression of interest had been invited by MD Monjusha. We have communicated with MD Monjusha in this regard, where tender formalities had been done before selection of this particular brand of ASPI or not. Reply thereof with Monjusha memo number so-and-so dated 3/12/23 is self-explanatory, is enclosed. As per available records, the hard file of Directorate of Horticulture was sent to the financial advisor to the additional chief secretary of the department for his views on 7th of December 2022. After getting back the same from the financial advisor, it was endorsed to the Director of Horticulture. The Director of Horticulture admin on 15th of December 2022. Thereafter, supply order was given by order dated 16th of December. It may be noted that approval from the appropriate authority had not been taken for issuing such order. It is learned from the senior DHOs over telephone that no requisition from the district office with list of beneficiaries was sought by the then Director Horticulture Admin, who was in charge of the scheme. No such requisition has also been traced out in the concerned office file. In view of the fact that MD Monjusha had not discovered market rates through a tender, we made an attempt to ascertain the rates for supply to government agencies from ASPE. However, they did not cooperate and stonewalled all queries. During details of procedural noting, communication with the issuance of supply order, procurement, disbursement, distribution has been made exclusively from the end of Directorate of Horticulture, concerned Assistant Director Horticulture in charge of RKBY, Deputy Director Accounts to the department, and the then Director of Horticulture Admin were associated with the procurement as per available records. Lordship, this is the first memo about the enquiry, Lordship. This is dated 26th of June 2023. Lordship, then this is 26th of June. From December, the initiation of the promotion for the post of Assistant Director to the post of Deputy Director.
So when the proceeding was started, again we are asking you, when a proceeding was started?
Lordship,
in their affidavit, page 6, paragraph 11, one of the categorically stated. Page 6, paragraph Roman 9.
And Roman 9. That is what I had shown. In response to the office memo, VDA's letter dated 28th of February 2024 stated that there was no departmental proceeding pending against 7 officers except Ronald Jayadotto, the petitioner. In the case of the petitioner, articles charge have been framed on 5th May 2025, and on the same date, inquiring authority and the presenting authority have been appointed. And
So nothing prior to 5/5/25.
Lordship, the process was on, Lordship. Prior to 5/5/25, it started from June when it was detected. That is
so
June
how you
2023.
deprived him consideration for promotion?
Lordship, there were 3 who were under, 3 officers, one more senior to him. It's not him alone. Out of the 10,
May have chosen to accept the situation.
out of 10 candidates, 3 had departmental.
We don't know whether he would have got or not. That's a
Lordship,
different thing.
Lordship, this is the question of integrity clearance, Lordship. The vigilance did not give the integrity clearance. Lordship will kindly see why this is required, Lordship. Lordship will kindly come to page 24R9.
That's not your case. Your case is pendency of a departmental proceeding.
Lordship, my case
Your
is
case is not that there was an integrity certificate wanting.
No, Lordship, my case is that these 3 officers were not given the integrity clearance.
No, where have you
Therefore,
stated this?
said
Please
that.
read where you have stated this.
Therefore,
That you requisition an integrity certificate which was not given. That's not your case. Your case is that vigilance informed you that there was a proceeding pending.
Lordship, but that the proceeding Vigilance has said there was a proceeding.
Vigilance says
pending.
nothing.
It was
Vigilance says there is a large scale irregularity in purchase of knapsack spray, battery, whatever it is called, which has been done without floating a tender or whatever. We are inquiring into it. That is an order given by the director. He is an assistant director wanting to become a deputy director.
Lordship, but the inquiry had
There was
started.
nothing against him.
Lordship, the inquiry had started and there was no, Lordship, as I said, there was no integrity clearance. Three
It's not
officers.
your case. You may submit it, but that's not your case. That is the documents on record.
Lordship, the documents on record show the.
None,
question of
just you store
integrity.
that expression from anywhere in your opposition. That's not your case. It's not a case of non-grant of integrity certificate. It's a case of a pending departmental proceeding. And the law by now is settled that proceeding can be said to be pending only after the date of charge memo, not prior thereto. And who is his junior? Who is your junior who was
But the
promoted?
private respondent, Shamantulak, I have served copy, but
Now he is retired.
no, he's still working, I am also working. But he is holding the post of deputy director, and but after this promotion, my lord, two further promotions, I may say, from deputy director to joint director had happened. So, my lord, there is a vacancy. That was also brought on the record before the learned tribunal.
No, for you to get any relief,
Yes, my lord.
anyone has to be removed.
No, my lord, there is still vacancies. That is what I want to say, my lord. But there is a government circular which says, my lord, if this sort of situation happens, but then the last man, either he has to be demoted or a supernumerary post has to be created. Either way, this could be done in terms of court order or otherwise. My lord, in the instant case, my lord, I may say, after the filling of a vacancy and after all those things, my lord, two further promotions were given from deputy director to joint director. So, my lord, these two posts again become vacant, and they're still lying vacant as per my instruction goes from my client.
Lordship, Lordship will
His claim is
Not-
Yes,
Lordship,
And my
we
lord,
have stated about the integrity clearance,
Yes.
Lordship. Paragraph 4 onwards in my affidavit, paragraph 6 is very clear that the integrity clearance was issued
please read.
with 3, Lordship. That in the meantime, Lordship, I think I start that the SVC West Bengal had informed the department regarding secret vigilance inquiry for alleged irregularities in the purchase of knapsack battery sprayer, 16 liters, which is annexed as R1, Lordship, that letter dated 15th of June. Thereafter, the SES of the department has informed the SVC West Bengal regarding involvement of concerned Assistant Director, charge of RKBI department, and the then Director of Horticulture, dated 26th. That is I also place. That in the meantime, the Department of Food Processing issued a letter to the SVC for integrity clearance in respect of those 10 AD, all the candidates, including the petitioner, with letter dated 18th of December 2023 for promotion from the post of Assistant Director of Horticulture to the Deputy Director. So integrity clearance was sought for in respect of all the candidates.
But
Lordship.
it's not their case that they did. They say that there is a
But this is-
disciplinary proceeding pending.
Lordship, that has happened. Lordship, that was as if we take the chronological events, Lordship, that has happened. The charge memo has been issued later. But the integrity clearance, Lordship, there too for the 3 officers, Lordship. Lordship,
Are you
please-
trying to justify non-grant of an integrity certificate without any proceeding?
Lordship, there is Lordship with all
Without
the
any
3.
criminal or departmental proceeding, an integrity certificate can be denied.
Lordship, there is a departmental proceeding pending against Dr. Datta by State Vigilance Commission letter number so and so 22 dated so and so.
It's imaginary. There is nothing. Till May 2025, there is nothing. May 2024,
Memo was
2025.
5.
Lordship, it's not that there was, Lordship, that was, the charge memo was given. But then, Lordship, prior to that, it's the process started from June 2020.
Therefore, we are asking you are repeatedly making that submission. We are repeatedly asking you, are you trying to justify non-grant of an integrity certificate without there being any criminal or departmental proceeding? If so, show us the provision where it can be done. Merely repeating the same submission is not,
Let me take
they
some.
can't be, simply can't be. An
Lordship,
integrity
let me-
certificate cannot be
let me-
denied till there is an order of punishment. Only then an integrity certificate
Lordship,
can be denied.
Let me clear, I'm on.
During pendency also he cannot be denied
Lordship,
because it will depend on the outcome of the proceeding.
Lordship, let me.
He cannot be
let me
punished
take
before he
in-
is punished.
Let me take instructions on this.
What instruction you will take?
Let me take that.
There is nothing. Only thing we want to know is whether for granting relief, somebody will be affected or not. Where is this fact on record that the post now is vacant? Show us.
Yes, madam, I'm just.
There are two things. See why we are pondering over it. One is that even if the deputy director post is vacant, it can be granted to you. At the same time, you are saying the further promotion to joint director has also been granted.
But to others, not to the private respondent, not, yes, ma'am, yes, your lordship is absolutely right.
So therefore, as a consequence of this promotion, if that junior has been granted a higher promotion, will you be claiming that promotion also?
No, madam, I may say, madam, I'm just clarify, lordship, my lord. But the junior has not been promoted to joint director.
Another one has been.
Others, madam.
So with them you have no
No, madam,
competition.
they are much more senior to me. I have
Okay.
nothing to say with regard to them.
Yes. First, where the vacancy is available.
I'm just, madam, from the OA itself,
Why you made him a party?
but if my lord, your lordship passes an order, and my lord, if the consequence, if the finance memo is come into play, either that person should come down or supernumerary post should be created. If no vacancy is there. So, my lord, if I have not made him party, my lord, he would come and say, it was done behind my back. So, my lord, I made it, I have served, my lord, the affidavit of services.
There is a service on the.
Yes, my lord, I have served him, but he didn't, he chose to appear.
Lordship will kindly come to. Lordship will kindly come to R9, Lordship.
Hmm?
R9, page.
Yes.
This is the issuance of integrity certificate. It has been decided henceforth that the cadre controlling authority in the respective department will issue vigilance clearance to the officers belonging to the respective services for the following purposes. And the purposes are laid down 5, where its serial number 3 is for awarding promotion. The above will not apply in the cases for officers under suspension, officers in respect of whom disciplinary proceedings have been instituted or are pending, has taken a decision to institute disciplinary.
Neither of the three are available with you.
But Lordship, for awarding promotion, Lordship, the integrity certificate is required.
But it says it will not apply in the following case.
Where there is the disciplinary proceedings have started, initiated. Lordship, in respect of whom disciplinary proceedings have been instituted and are pending, Lordship. Then it will not be required. But if that is not the case, then it is required, Lordship.
But C also says, well, whether disciplinary authority has taken a decision to institute a discipline against officer. It's not required, my lord.
That is.
I may say, my lord, if they have written that to PSC.
Lordship, then, I mean, if that is the case, then Lordship, we can't say, I
On
mean,
careful it has been
integrity is
decided
under
henceforth the
question,
cadre
yes, Lordship.
controlling authority issue vigilance clearance to the officers. Very well. So at best you can claim to come under C.
Lordship, that is when it is not required. I mean, but in case of giving a promotion, Lordship, it is required. I mean, he doesn't.
Maybe we are not reading it in the same way.
Lordship.
See what this
Lordship,
letter says is
Lordship.
on careful consideration, it has been decided that henceforth the cadre controlling authority will issue a vigilance clearance for these purposes. It will issue, but it will not apply in the following cases. That means it will not be issued where he is under suspension, where there is a criminal proceeding or disciplinary proceeding instituted, or where a disciplinary authority has taken a decision to institute a disciplinary proceeding. This is the way it has to be read. So 1 and 2 definitely is not there. He was neither under suspension nor against him a disciplinary or criminal proceeding has been
At that point
instituted.
of time.
Where is the decision to institute a proceeding against him?
Not applied.
Lordship,
There is no decision. Everything is in contemplation, even if there is a decision. This circular, it will not stand in view of the decision of the apex court. It is at best conceives of a situation where in contemplation of proceeding, he can be denied a consideration. This is precisely the issue which fell for consideration in the case of Union of India versus KV Janaki Raman, which the Supreme Court said it can't be done.
so Lordship,
KV Janaki Raman judgment is prior to this, still government is issuing.
1991, I do have the judgment.
Yes, and this just circular is of 2000. We don't know what the
Even
government.
after, my lord, is KV Janaki still holding the field. In 2012, Anil Kumar Sarkar came in, where 4 proceeding and 4 criminal cases were there. And my lord, your lordship passed an order, me Muhammad Yashin, where I was respondent, my lord, issues are same. Date of proceeding, date of promotion in the month of March, date of proceeding in the month of April. My lord, tribunal allowed my petition, state has moved the writ petition before your lordship, my lord, and your lordship has decided in the favor of the respondent applicant, and it's also been reported in the court cases, my lord. That is 2026 SSC online Cal 4020. Exactly, my lord.
4020. SEC online. Thank you.
And within that provision, you said that either the person has to be demoted or superannuated.
That is not here in the writ petition. But this is a circular, I know that, my lord. I had opportunity.
Therefore, there is a chance he may be asked to be demoted.
But I have made, that is the reason I have made that person a party.
Where is the service? We have recorded a service.
Yes, my lord. Affidavit of service must be on record, my lord.
No, in the proceeding, have we already recorded valid service?
Yes, yes. It's all, your lordship will find it has been served and he has received it from the affidavit of service. If your lordship picks up. There's only one my lord, postal service is there. And the PSC को post देते हो चुके जाएंगे. My lord, may I get one service, my lord? I don't have a copy.
No, we are not recorded any valid service yet. There may be affidavit. Where is the affidavit? What is the date of your affidavit?
Affidavit of service.
Seventeenth April. Oh, it is very recent.
25. The 26 matter. This is the 2026 matter.
Hmm? His private respondent is respondent number.
Item delivered.
Let's go and see on it. There is only one affidavit of service. You have a copy?
Your lordship might be, it's my fault, my lord. I have not.
No, that is not the point. The point is, where is the service on respondent number 5? Please see. Please read your paragraphs at the second page. You have said respondent, government leader, you have said respondent 2, 3, and 4, but you have not said anything about respondent number 5.
To PSC, to PSC, to PSC. Receive to PSC, this
My lord, although I have not stated, my lord, your lordship will find this. It's postal receipt is there, and my lord,
We don't know.
my lord,
How can we see it if you
my
don't?
lord, I should have checked it, my lord, it's already also delivered.
File a supplementary to that.
My lord, it's not been, it should have been stated, my lord.
It has to be, otherwise how we can look into the document in absence of any pleading?
My lord, that's true, my lord. I was,
It's a writ proceeding basically.
this is your lordship will find the postal ticket.
What we'll do is, today, whatever we have heard, we will record that. You effect one service afresh, and then we'll take it up. Heard the learned advocates representing
I will serve the copy of the petition along with your lordship's order.
Everything, yes.
Everything I will serve. I know
All the
affidavits both and
That
your
is
lordship.
why we recorded the order, so he should know what is going on.
Absolutely. I will serve it.
Yes.
That's my fault, my lord. I should take the responsibility. I cannot blame any other.
Parent 12.
Thank you.
I am for the respondent. My lord, on the last occasion, your lordship's pleasure.
You are for the respondent.
I am for the respondent. Last occasion, your lordship's pleasure was to direct that they are at liberty to file a supplementary affidavit. But possibly they have changed their mind. I have not been served any.
You are for?
He is
The
for the
petition.
petitioners. My lord,
So what you have done?
I learned that his senior has asked him to take time today.
So has he got the documents? Nothing. Not today. Let's see what happens.
Let it be on next Wednesday.
An adjournment is sought, full stop. Matter is adjourned to
Parent 13.
I'm for the appellant, my lord. I'm paying for my lord adjournment, my lord. Let the matter be fixed after 4th of August, my lord. This is the appeal, my lord, suit for specific performance of the contract, my lord. Mr. Shakoshin was arguing the matter, Mr. In his personal ground, last time also I took adjournment, my lord. His father is very ill, my lord. He is still hospitalized. And
So where is your opponent? He was here.
The respondent number 3 in this matter.
We are informed by MS so and so.
Parent 14.
It is.
I appear for the writ petitioner respondent over here.
Lord, I am for the appellate.
You are for?
Appellate.
So not today. Let the state be represented. Will not pass any order, just not today. Tomorrow is all right? Tomorrow is all right.
Russia is posting it at.
We are passing an order. Without passing an order,
no,
we are adjourning it not today, unless you want on another day.
Not today, it's fine. Let me, tomorrow. Learns.
Mr. Sanyal, there is a prayer on behalf of the state.
No, I also pray for that because I am not prepared first.
So he is the only one ready.
Friday. Take it up next Wednesday.
Any objection?
No.
As prayed, list on, give the.
It's against a recalling of the order, which was taken up by the Judge Singhal against an order which was been recalling preferred after 8 years. Recalling allowed, section 5 allowed, without giving any opportunity. Your lordship took up this matter on the aspect.
Let's see.
Division bench covered the issues actually.
Let's see.
I'll be coming with another division bench. Grateful. Let's come back on Wednesday. for the-
Wednesday.
Wednesday.
Item 15,
For the directive for the application. Lordship, there's a section 5 application, Lordship.
How many days
It
delay?
happens to be can 1 if I'm not mistaken.
How many days of?
155 days delay as far as we are.
But I am opposing the section 5 application. Your Lordship, kindly see the last order, my lord. Order dated 12th May 2026.
Copy that.
Copy দিয়েছি আগের দিন দিয়েছি জজকেও দিয়েছি
आपके पास brief है नेटवर्क में order
ও ওই আগের দিন ওরা টাইম
Sir, that we ask you about delay. We are not asking you about your preliminary objection.
So delay on in respect of delay.
Why you are showing this order, how it concerns the delay?
This, my lord,
Yes.
the appeal they have already complied and subsequently the
How does it concern the condonation application that we are asking?
condonation of delay, they have referred to the bunch of document, my lord. I'll show this document. Kindly see.
So how this order is relevant to the condonation application?
What is their intention to prefer the appeal? That is a delay, my lord. Delay caused due to some bona fide intention, my lord.
So let us come to the can. Why you are showing this order? This has order, the order has nothing to do with the
Very well,
can.
my lord, Lordship, kindly.
Unnecessarily you are showing this order.
Very well, man. Your Lordship, hear out the can, I don't know.
Can, what is the can number?
Lordship 1.
Can 2.
Can 1 ही होवे, can
Section 1.
normally what happens is we initially we used to file the stay and then section 5 and we used to number it according to our consensus as 1 is stay and 2 is section 5, but the department has now started that since the appeal is an honest, so they automatically number as 1.
Maybe it is better to number.
Yes, Lordship, because the concept, as we have understood that the appeal is honest
Yes, how is
until
taken?
unless section 5 is allowed by your Lordships.
Yes.
Then only it will. So, Lordship, there is 155 days delay, Lordship. Lordship, we have pleaded the delay, Millets, regarding the fact, Lordship, that in getting the opinion or preferring this appeal, certain time.
What is the issue on merit?
Lordship, the issue on merit, Millets, what
Because he has
what
raised
I
an
would.
issue that there is some suppression of material fact, therefore we are asking.
No, Millets. My lord will kindly appreciate. There, basically, I have 3 points on merit, limbs of submission, which I will try to amplify maybe any day, Millets, because after section 5 is allowed. Initially, a particular lordship, an event took place. Just cursorily, I am taking my lords as to the factual, what I have understood. My learned senior friend may not be on the same page. But an event took place. This particular respondent or the petitioner before the Honorable Single Judge was charged with a particular, he was charged with a particular offense, and then after that, Millard, he was given censure and that particular matter ended there. Subsequently, Millard, on investigation regarding the same incident, certain other facts were unearthed. Based on those facts, we started to another proceeding
on the same fact.
Yes.
My lord, that is very intriguing, Lordship, because all that glitters is not gold, Lordship. I can understand, Millard, the first thing comes on the same fact, but I will try to my best competence, Millard. That, Millard, my basic argument, what I am trying to amplify is, Lordship, is, Millard, that Rule 37 and Rule 36. Rule 37, he was granted censure. And Rule 36 culminating into a final order. Now, there's a difference under section Rule 37 and 36. And the Honorable Single Judge came to Rule 54 and decided the matter. This is one. Second limb is, Lordship, at the very outset, when the writ petition came up as motion stage, we were not even allowed to file our affidavit bringing on the facts that what was the subsequent event which gave rise to this particular proceedings. And third aspect was this also, which I have to take instructions, Lordship, because here a higher official has been charged later on. Now, under those circumstances, this particular respondent was called to give witness. So, my lord, I will amplify.
Was called
to give as a witness also. So, my lord, that aspect is also to be looked into, Lordship. So, my lord, what I am humbly submitting, if my lord so deems fit and proper, it's an argument. I'll not take much time, but my lord, if section 5 is allowed, my lord, I will file a short notes of submission. And my lord, that is the only point. If my lord finds that it falls within Rule 54, which
of CISF.
Lordship, I
No, 54 is to be preceded by a notice.
Lordship.
Was he?
My lord, yes, my lord. Natural justice, my lord, what happened, my lord? I will kindly see, my lord. Initially, my lord,
What is the
26th of May
allegation?
2022.
Allegation, my lord, that the allegation was, my lord, the writ petitioners and other officers, they have allowed to enter a.
You are an officer.
No, he's a constable.
GD.
Constable, yes, constable GD. He allowed enter into a Babughat, Port Trust area, and also allowed to go there. Initially,
He allowed some persons to come in the secure area.
Secure area, other person as the other constable was there. So initial inquiry was made before charge sheet was issued, where it was specifically found that petitioners, my client, has not been benefited with such incident in anymore. Thereafter, a charge sheet was issued under section 37, Rule 37. Then order was passed censor by the disciplinary authority.
Lordship, that was.
Well, censor order was implemented in the record that I will show. Then I filed a writ petition. Then censor thereafter, there is an appeal provision under section 54. I did not prepare an appeal. The authority concerned should want to review the matter. In review, upheld the censor order.
No, you said the censure was challenged in a writ proceeding.
No.
Not challenged. No appeal, nothing.
Neither way.
You accepted the censure.
Yes, I have accepted. I have not
And
prepared.
subsequently, a harsher punishment has been imposed.
No, my lord. What happened? Yes, removal order, harsher punishment. What happened, my lord? After that, my lord, censor happened. The authorities want to.
Don't get impatient. Please sit down, sir. Please. Yes.
Authorities want to review that censor order, my lord. Ultimately,
I'm not in haste. Don't worry. Yes.
So I want to review the order, my lord. And thereafter, my lord, charge sheet was issued again. I challenging the charge sheet.
Oh, charge sheet was issued again.
Yes.
Okay.
Then, my lord, I filed a writ petition holding that the censor has already been passed and it has been implemented. So you cannot take saving against me because I am not faulted. Thereafter, my lord, even if I was not allowed to file a writ petition, I was not allowed to give any leave to file a writ petition. My wife has to file a writ petition. That was the strategy of the authority concerned.
So what happened?
What happened? Thereafter, my lord, challenging that, my lord, since the censor order has been passed, so they cannot proceed in the same cause of action.
Yeah.
The impugned order was passed. After the impugned order was passed, my lord, they issued a notice to me calling upon on the same inquiry for evidence or statement inquiry. Then I again filed a writ petition. The matter has already been disposed of. Nobody has challenged. No appeal has been preferred either in the censor order or against the impugned order.
You want to appear as witness?
And they appeared. No, I don't want to appear because the matter has ended there. Thereafter, they said, no, we are not taking any steps against him. It is recorded. Not against another commandant. Against the commandant, we are taking steps. So on that basis, that writ application.
So in that inquiry, probably they have realized that.
Commandant. But that has been disposed of on the basis of their undertaking. No, we are not taking any steps against the petitioner. Thereafter, my lord, they went on asking for opinion. All the authorities, higher authorities says it is a no fruitful purpose to prefer this appeal. They have disclosed all the letters in the section 5 application.
Perhaps during the inquiry of the commandant, it was discovered that his role has to be re-examined.
And
So that is
I
the
have
only
judgment,
point
I
I
have
was
a
trying to
judgment
agitate.
after 37, they
But
cannot.
can it be done? Can it be?
I have a judgment 37, after 37,
My lord,
after they cannot proceed with the
my
36.
lord, may I? There is only a
So
small,
we'll hear it out.
my lords,
Fix a date in the next week. We can hear it.
lordships. Because there, I will not
The
take,
issue is very short.
lordship,
Whether
that-
it can
that's
be
what I pleaded.
re-agitated or not, that is the only thing.
I pleaded that, okay?
Therefore,
And
your
my lord,
lord,
another
that
aspect.
Section 5 application along with the appeal will be heard.
and-
Initial, from the very beginning.
and lordship,
Always your lord to be the
another
judge.
another aspect, I would like to take instructions from your client that with regard to that writ petition, if we have made certain,
I requested my learned friend, senior friend, my lord said that in terms of the second order passed by the learned single bench, you confirm that order, everything is finished.
My lord,
He has
of course,
said I will
my
take
lord,
instruction.
because
What is the writ number?
Read number is there, I mentioned, my lord, that is
Okay,
writ.
very
It is recorded in our earlier order.
Yes, recorded in the earlier order. That order, if they confirm, I don't mind.
my lord, let me take
Well, 47 and 48.
My lords, actually, I have gone through the entire.
I filed the opposition to his stay application.
Stay.
Number 47.
Oh, there are two. You have also filed an appeal.
That's item number 48. There is a delay of 31 days in preferring the appeal. To which he has used an opposition. And I have also prepared a reply.
So you have also filed opposition to the stay and you have also filed an opposition.
This is my reply in connection with item 48, but there is a delay of 31 days.
The affidavit in opposition.
My lord, that this stay applied, which is totally relying on the clause 3180 of the bank's promotion policy. However, the clause cannot be applied respectively after the panel had operated and my junior has already been promoted. If
You have got the relief from the single judge. You have got the relief from the single judge.
yes,
Then why you have filed appeal? That we are asking.
I have appealed for the further promotion, so further reliefs.
But you did not press for the further relief.
I have in my appeal, I have.
How can you, before the single judge, you read paragraph 47? Read para 47 of the order.
The petitioner did not press for any further promotion according to his prayer. Grant for
When you have not pressed for any further promotion, how the single judge?
there in the 17 that has been recorded.
That is,
I have
see,
pressed.
you have not pressed. The order cannot be wrong.
My lord, I have pressed it and submitted a written, given a written submission for that.
Written submission means nothing. What you argue is considered by the court. In your written submission, you may raise 15 submissions. You may argue only 2. So the court will not consider the remaining 13.
My lord, it is there in the writ petition.
It is not open to say that in an appeal. Please try to understand what we are saying. There is no scope for taking such a ground in appeal. If it is recorded in the order that you did not pray for further promotion, the remedy is not appeal.
My lord,
You appear in person, that does not mean you can do anything you want.
my lord, that has been there in the writ petition also.
How many times you will say that? What we are saying, you are not listening, you are trying to say the same thing again and again. If it is recorded in the order that you have not pressed for further relief,
My lord,
it cannot be raised in an appeal.
order para 17, it is there. I have the para 17 says the petitioner pays for the direction upon the bank to grant him national promotion to the next higher post of assistant general manager with effect from 1st June 2015 and further national promotion to the post of the deputy general manager with effect from 1st March 2018 and general manager with effect from 1st April 2021 in the same line as his immediate junior. It is there, it is recorded.
You cannot argue in appeal. Please try to understand what we are telling you. You cannot argue this in appeal. If this recording of submission is wrong in the order, appeal is not the remedy.
I do not get the point. I have submitted before through the oral arguments.
Again and again you are saying the same thing. We are not saying that you have not said. We don't know whether you have said or you have not said. But this is not the remedy. It cannot be raised in an appeal. There is another remedy for this. If there is a wrong recording of submission in the court's order, then remedy is not an appeal. Unnecessarily, you are wasting your time in an appeal. Everything, it is a detailed order, 52 paragraphs. Everything you have said has been considered. In paragraph 47, it has been noted. This note has been made on what is the date of the order? April 2026.
Lordship, it is, I have praised for it. Repeatedly, I said that I have given the.
Repeatedly here also you are saying.
That the case
Repeatedly
was-
here also you are saying. The
case
point
was I
is,
have presented.
you are in person, therefore we cannot help you. We cannot help you. If you don't want to understand, then we cannot help you. You are in person, that does not mean everything. You can say anything you want and we will do anything you want. There is a scope for arguing things in a particular jurisdiction. If it cannot be done, it cannot be done. Whether you are in person or through lawyer, how it matters? This is not an issue which can be raised in appeal. There is a different remedy. You don't know the remedy. How can we help you? And you don't have a lawyer.
Since the consequential promotional considerations have been not been considered there, I have come to the.
This is not a remedy. How many times we will tell you? You don't have appreciation of the legal process. We understand that. We appreciate that. But that does not mean everything will be thrown to the winds for you.
My writ petition is containing that appeal. That is in the prayer itself and in the subject content it is there.
You realize we are irritating you. Realize that we are irritating. But the law does not permit, sir. Realize we are the remedy for everything. You are not remediless, but this is not the remedy. And you don't want legal help.
Last time it was also discussed review petitions. It was
Certain that on the last occasion I have said this and you have said that. Paragraph 47 records the specific submission on your behalf. You say it is wrong. Can you say you are wrong? It is wrong. You can say, but in an appropriate proceeding, not in appeal.
But my lord, in spite of that matter was presented, means it was not considered by the learned single judge.
Saying that all day. You can keep saying it all day. That I have said is still not considered. We are not saying you did not say, but we cannot it in appeal.
Still, my lord, I have not gone for the review of the order because it is said in the 47 that it has not been pressed.
That was the only remedy for you. That was the only remedy for you. Because you said this is wrongly recorded. If some submission has wrongly been recorded, only remedy is review and immediately. The Supreme Court says it must be raised immediately when it is still fresh in the mind of the court. There is a wrong recording in the order. You are beginning to appeal. If we start doing that, every judgment will say no. The facts are recorded wrong.
Whether I can now, because I don't know legal, I can file the review now.
We are not here to advise you.
But I don't know now. That's why I'm.
Then you can't do this. You don't know, then you have to go to legal aid. Or you have to engage a lawyer, not to ask the court. You don't have that kind of liberty.
Can order, sir, my lordship, can order be issued to file the review in that case? Otherwise, I don't know, the time may be in the limitations. I cannot, I will be helpless in that matter. I appeared after the death of my advocate. I appeared in person.
You are coming from Bhubaneswar. If we remember correctly. Last day you said that you are coming back.
Actually, that was delayed. That was looked after by my advocate, and it was delayed for 1 decade almost. Means 7 to 8 years, and he did not. There was no progress in that. After his death, I appeared in person before the learned signatures.
But you didn't want her to file a review. How you have a lawyer. Say, it's not the way.
Huh? Hello.
Such cases, we are on trial. What to do? We don't know. We don't want you to suffer.
I consulted.
Please try to understand. We don't want you to suffer injustice. That is why this anxiety.
Actually, I consulted with the lawyers from one friend from Supreme Court and also an advocate from High Court of Cuttack, Odisha, and they suggested me to appeal to file appeal before the division bench, not go for the review petition. Actually, I am not knowing. I just consulted with them.
That is why we are taking so long. Some lawyer by now the order would have been passed.
Sir, only because that was delayed for the 7 to 8 years.
Understand what you are trying to say. We have understood. Why the case your lawyer for 8 years, according to you. Thereafter he passed away. You had no option. You started appearing in person. You asked some lawyers. They said file appeal. Now they are going for a appeal. How that helps you? Ultimately, you have to do something which helps you. These submissions don't help you.
Major Lordship will give the order for filing the review petition since this is not the appropriate forum for appeal.
His appeal is of course not maintainable. What more can I submit as an this being a court of records, not this will be really an unfortunate incident. Yes, my hearing has to have.
Want to engage the sense of some lawyer.
I don't know any advocate here. Actually, once I have suffered, sir. Once I have suffered, I have paid much more, but did not get any benefit. For years, sir. For I can afford, but only thing is that nobody is known to me here, sir. Nobody is known. I am new completely here.
Yes, take down.
Record.
This was take some help. Order pass.
My lords, here 30 days time is given for the filing review.
Down. It is the learned, the
of the advocates had inquired from us that how long will you take? We said it at least one.
Yeah.
And one person ultimately mentioned that he shall be questioned.
What happens?
Item number 16.
Item number 16, I am for the petitioner appellant. If my lord may
I am
come,
for the lordship.
last order of my lord of 1st of July 2026, your lordship was pleased to admit the appeal and directed the state to file an affidavit in opposition. And the returnable date was fixed for today. Paragraph 7 and 8.
Yes, I'm praying for no lordship, I'm praying for an extension of time.
the
Sir.
Grateful lordship.
Item 17.
My lord, Mr. Sarojit Sen is appearing on behalf of the petitioner. He is in different court. I'm praying for Passover.
Item 18. Item 19. Item 20.
এই পেছনে বসুন না, কাজে বসুন। থাকে না। On the last occasion, let's query about regarding Malat statement of Malat wife during the inquiry, officer Malat inquiry Malat. Devashri, kindly come to Malat page 62 Malat. Yes. 59 is the Malat list of witness Malat, volume 1 Malat.
চাইছি এটা নেই তো লিস্টে দেওয়া নেই এটা নেই লিস্টে দেওয়া
List of prosecution witness Malat. And then next Malat, page 60, prosecution exhibit. Next page. And then Malat 62 Malat. Regarding Malat first wife Malat This version, my lord. Translated copy of statement of Pusha Devi, my lord. That is first wife of the, my lord, accused person, my lord, that where suspension has been and termination has been done by the respondents, my lord. আমার 5টা পেপার বুক আছে, তুমি বসো না, আইদার দিকে আসুন, চেকিং করে আসুন। Yes. The another witness, paper with family members, কত পেজ আছে? হ্যাঁ, the witnesses are, my lord, there are 5 witnesses, my lord. Prakash Singh, my lord, Railway Authority, my lord, the Pusha Devi, that first wife, my lord, and then Visharanda Giri. He is a priest of the, my lord, that ashram, my lord, Moni Baba Mott, Subhapur, Chakradharpur, Gazipur. Chokpur. Chauchakpur. Be clear. And then, my lord, Sheikh Samsuddin, West Security Metro Railway, Kolkata, or and any other witness inquiry desire.
Service records. The first 5 continues to be the
Yes,
same.
yes. And then, my lord, you should kindly come to, my lord, page 60. Page 60, next page, my lord, paragraph 12.
Para 12 of?
Para 12 of page 60, next page, my lord.
What is it?
This is, my lord, copy of the application which has submitted by the, my lord, first wife.
The documents which were adduced by
The documents which was adduced by the, my lord,
the first one.
She has submitted some information obtained from the MUT.
Yes, my lord.
Where is that? Which page?
Page, my lord, 60, my lord.
No, where is
Para-
that information?
Para Roman 4, my lord. Bottom portion, my lord.
No, sir, we are asking you, where is that information
Page
which
76, my lord. Translated copy, page 77, my lord.
that is a photocopy of the register?
Yes, my lord. Hindi version, my lord. And then
So which is the relevant entry at page 76?
relevant.
The first one.
Relevant, my lord. First name Jitendra Kumar Jadhav, that is, my lord, the husband of the, my lord, that wife.
Serial number 61 was the entry.
Serial number 61, my lord. Yes. Serial number 61, my lord. Miss Archana Jadhav. That is second wife, my lord, name, my lord, which is reflected in the, my lord, marriage register, my lord.
And he has got it under RTI.
No, my lord, that is.
This is what she has stated.
Yes, yes.
She has got an information from the MUT under RTI.
Yes.
Yes. What else? There is a photograph.
Yes, my lord. Photograph.
Page
both,
75.
Yes, my lord. Both husband and, my lord, second wife, my lord. বলবে তো একটু বলবে
There's a brighter.
বলবে না কিছু?
So this is only two material.
Yes.
And
also, my lord, marriage, my lord.
anyone has appeared from the MUT?
Yes, my lord.
Which PW?
Giri, my lord, that is, my lord, page 59. Vishuddhananda Giri.
Vishuddhananda Giri.
হ্যাঁ, Feast of Siddhapit, Sri Mauni Baba Mott. Page 59, para 3, my lord.
Page 59. No, it is page 59 is something else.
Page 59, my lord. That is list of prosecution witness, my lord. Page 59, volume 1, my lord.
We are asking you, where is the statement of this gentleman? PW3.
Yes, my lord. Just 1 minute, my lord. এটা মনে হচ্ছে নাকি মনিরাম যাদব এর মধ্যেই হবে এখানে আছে মনিরাম যাদব দেখলাম তো।
No, he is PW5, not 3.
মানে
Where is his statement? PW5 statement.
marriage record is there, my lord. That is volume 2, page 171. And onwards, my lord. Marriage record, my lord.
Marriage record.
Yes, my lord.
What is marriage record?
দেখেছিলাম
All right, you argue what you want to argue. Forget about, we are not asking you
Yes.
anything. You argue what you want to.
That is the main.
Every day we ask you something, you are unable to tell us. So you argue what you want to argue.
No,
What
Malad.
is your preparation of the appeal? Tell us. You have only 5 PWs, you can't locate their statement. Then you argue what you want to argue. What is wrong with the
The
honorable single judge?
statement, Malad, statement made by the Malad wife, Malad, that is Malad.
That we have seen. What else?
And then Malad, রুলসটা পড়ো রুলসটা হ্যাঁ কত পেজে লাস্ট ভলিউম You see, Kali come to Malad, page 412 Malad. Volume 5 Malad. That is RPF rules, Malad. 1987, Malad.
Yes.
415, Malad.
Yes.
The resume of uniform article of seizing of the enrolled member of the force. And next, Malad, suspension.
What is it you are arguing? Why you are showing this rule? We fail to understand what you are trying to say. Why you are showing this rule? What is your submission? This rule is in support of what submission? Which
On the
fact?
last occasion, Malad.
Forget about last occasion. You tell us today. On the
Yes.
last occasion.
That is a problem, Malad, because I have already argued several times this matter, Malad. Although, Malad, your lordship know that only question is that, Malad, whether this marriage is solemn is valid or not.
Only
Number
question
one.
is whether there was
Number one.
any evidence before the inquiry officer to arrive at a conclusion.
Yes, Malad.
Now we are asking you repeatedly, which is the evidence you are relying upon? You are just fumbling with the report.
Evidence,
What can we
Malad,
do?
evidence only, Malad, certificate, marriage certificate, photo.
Certificate and
Hindu
photo.
Marriage Act, it is enough for, Malad,
All right.
as far as this marriage is concerned.
All right.
Number two, Malad, who is the complainant? That is the important. First wife. First wife is the main complaint, Malad. Not neighbors, not other party, not third party. She is the main complaint as far as this case is concerned, Malad. This force is, Malad, very disciplinary force, Malad, according to rules and other proceeding, Malad. That is already enumerated by the, Malad, authority, and all the proceeding, your lordship, kindly come to, Malad. As far as this, Malad, witness 3 is concerned, Malad, that is Vishwananda Giri, Malad. Statement of Vishwananda, page 96, Malad, which your lordship inquired previously, Malad. Sorry, Malad, this is a 5 pages paper book, that is identification, volume 1, Malad, page 96.
That is not his statement. That is recording by the inquiry officer.
Statement of Vishwananda Giri, on being asked, he stated that voluntary without any pressure that Jitendranath Jadhav, late Mongol Jadhav, village A, was married with Miss Archana Jadhav, district A, on 25th June 2020 at Mouni Baba Mott. The mott is registered by the UP government, Subhapur, Chakchakpur, that is, and Gazipur, UP, by me as in charge of head monastery in presence of the available witness, and mentioned that their name and address, Sri Jitendra Kumar Jadhav and Miss Archana Jadhav, in the marriage register of Mott with witness name. Accordingly, a letter was issued in this connection, which is marked by EO Exhibit 27 and a photograph of marriage registered by serial number 61 in where mentioned in the name of Jitendra Jadhav, late ato. This is with mention the date of marriage on 25th June 2020, and also mention the name of witness for Sri Jitendra Jadhav, Rajesh Jadhav, that is witness that Your Lordship. This is the statement of Malad that Vishwananda Giri, Malad, that is the one witness before the mort, Malad. And then Malad, the exhibit এটা 17 এক্সিবিটটা একদিন পড়ালাম তো দর্শক then Your Lordship kindly come to Malad page 92 Malad, statement of Malad Pusha Devi, wife, paragraph 2 Malad, volume 1 Malad, page 92. On being asked in connection with the above, she is Pusha Devi, permanently reside Ato. She got married to Jitendra Jadhav, late Mongol Jadhav Ato. According to Hindu custom, after her marriage, her husband Jitendra Kumar Jadhav got a job as constable in RPF Metro Railway, Kolkata, and posted at RPF Post Belgachia, North Company. After his job, due to their marital physical relationship, a girl was born whose name Jigasha Jadhav and nickname Tonu. Then my husband cheated, harassing on her for a dowry, kicked her out of his house. Since then, she has been living in her mother's house with her baby. She has an only daughter who is in 5 years old. Her husband Jitendra Jadhav secretly got married to Archana Jadhav, daughter of Premnanda Jadhav, village. This is Siddhapit at Siddhapit Baba Mott. She lodged an FIR number Ato on 8/12/2017 in regards to dowry harassment against her husband at Thana Bakura, Gazipur. Photograph is FIR enclosed marked as Exhibit 6. She complained to the Rashtriya Women Commission at New Delhi about the second marriage of Sri Jitendra Jadhav. Then she got the copy of NCR from Thana Bharakunda, district Gazipur, is enclosed marked as on 25th June 2020. She attaching the photograph of the second marriage certificate of Sri Jitendra Jadhav at Ato is letter is enclosed marked at Exhibit 8, which was issued by the in charge Siddhapit Sri Mouni Baba Mott. She also submitting a photograph of birth certificate of her daughter, namely Jigasha Jadhav, her nickname that is, on being asked, Pusha Devi has proved by submitting her Aadhaar card, and she is also wife of Jitendra Jadhav. It is clear, my lord, as per our impression that as the inquiry officer and respondent, my lord, that documents is, my lord, is very much true and also, my lord, applicable for this, my lord, evidence, my lord. এই আমাদের অপোজিশনটা কোথায় কোথায় গেল পালিয়ে গেছে আমাদের অপোজিশনটা কোথায় তা আছে এখানে আছেন না
Yes, very well. So statement of the wife, statement of Vishudanand, the register and the photograph. This is sufficient to establish the fact that it has been recorded in the inquiry. Therefore, there was no scope for interference in the writ proceeding. This is your submission. That's all. Yes, you are appearing.
My lord, Commissioner, my lord, I am pressing that the photograph which were they are claiming that the photograph is the only documents, only evidence. That photograph, I raise objection against that photograph, that that photograph is not it is a manufactured one, and it is a manufactured one. I raised several objections, but they are not at all get the emphasis on my objection. But in spite of that, they passed the order. And another thing is that certificate of the MUT, that my lord, that is page 76. My lord, kindly come to page 76.
Yes.
It is only a certificate. There is no signature. Nothing is written. Nothing is there. Nothing is there. My lord, 77. Only name was written.
No, it's not a certificate. It is a marriage register.
Page of a page of
Yes, page of that register.
one Xerox copy or photostat copy of a page of a register. They are
It is
claiming
there.
that this is a certificate.
Left-hand side.
That is if I admit that this is a certificate, there is no signature of the witness, no signature of the bride, no signature of the groom. Nothing is there. So that is why it is that time it was also disputed, but that was not taken into consideration by the inquiry officer in the disciplinary proceeding. And another thing, my lord, kindly come to page 96, my lord. The statement of the PW5 was not annexed with this paper book, and my reply also not annexed in this paper book.
Yes.
My lord, that PW5, that's Vishudananda Giri.
That's not there.
Statement was not there.
That's why we are asking him. He is not able to show that. That is why he's not.
Statement was not in the paper book, and my reply is also not in the paper book. That is why I raised objection that my reply was not in the paper book. They have exchanged the paper book, but in spite of that, I am not finding
So
my.
you have a copy of your reply?
Yes, lordship.
Then
But
show us. You
Lord,
can.
that file was didn't came. Let the produce before at 2 p.m.
Yes, come.
Thank you.
one matter before justice. My lord, we have heard that judges can do anything. Now I got the, my lord, the on hand evidence. Her first appeal in criminal appeal, she want to keep the records. The first appeal she has argued, but his her name has been changed as Mr. As any day suits my lord, sit in chamber and get it done. Hey. Yes.
কার কার নাম তো দিতে হবে কার কার জমিনদারা তোমার
One and two.
My lord, I appear on behalf of the respondent, my lord, in this matter. Yes, ma'am.
Judgment as 18/5/25. For that correction only.
As a lordship.
Yes.
Continuing with item number 20.
Yes.
Kindly come to page 66 of paper book 1. But while passing the order of by the learned single judge, my lord, I am emphasizing the page 230 of the learned single judge's order, that the evidence which produced by the complainant, which was not established, which was not proved by the complainant, that is a cogent evidence. Because, my lord, kindly come to page 66, my lord, where the statement of the complainant, it's a typed copy, my lord. Page 65 is a Xerox copy. But as per the marriage certificate of Siddhapit Moni Baba Mat, Shubhapur, Chochakpur, Gadipur, UP, provided by you in support of the second marriage of Jitendra Kumar Jadhav, that is the delinquent, so and so. Can you prove that your husband? That is, sir, I have been marriage certificate. Sir, I have been asked marriage certificate through RTI with the endorsed the name and address of my husband from Siddhapit Moni Baba Mat. Accordingly to the information I got and the said document, I have been deposited. Then next question is, this is a cross-examination of the complainant. Is the identity card of Jitendra was attached with the marriage certificate provided by the Siddhapit Moni Baba Mat, Subhapur Chochakpur, so and so? No. Then can we come to page 70, Lordship. Continuation of the cross-examinations. Question number 10.
page?
70. It's a typed copy of page 69.
Yes.
If you have submitted joint photograph of second marriage of your husband, do you identify the girl in the photograph? Sir, I don't know about the girl available in the photograph. How can she say that that is Archana Jadhav? She even admitted before the inquiry officer that she don't know the girl. And she didn't identify the girl. And she is saying that that is Archana Jadhav, and Jitendra Kumar Jadhav solemnized the second marriage with that girl.
Question number 10.
10. Where did you get the said photograph? Sir, I have not disclosed the name and details of person who provided me the said photo, as his life in danger and it can be difficult to him to live in the society. If that be so, she produced the photograph of that and claiming that photograph that Jitendra Kumar Jadhav had solemnized the second marriage, madam. That is the irregularity in the proceeding, my lord. And from whom is there threat of life of the person whom you get the photograph, sir? The person who gave me the photo is in danger of life from Jitendra because Jitendra can kill him. What is her submission? I don't know, my lord. And thereafter, my lord, I am placing the statement of that alleged girl. My lord, that statement was not annexed in my application under order.
No, there is no dispute that she has denied.
Yes, she has
There
denied.
is no dispute. Inquiry report also does not record anything to the contrary.
Inquiry report has endorsed.
So it also records that she did not support.
Yes. Yes.
So neither the husband nor wife say that the marriage took place.
Yes, Lord.
This is your sum and substance.
That's my sum and substance and the learned single judge, but the findings of the learned
And the complainant also makes according to you, makes a vague allegation regarding a marriage.
Yes.
Which is not supported by any cogent material, even on the preponderance of probability, it cannot be ascertained. This is what you are saying.
And I must say that that complainant also alleged that same allegation in the year 2017.
Earlier.
Same allegation. 2017, they have some conciliation meeting before the authority, and thereafter the complainant withdraw that complaint. And thereafter, in the year 2020, she made same allegation in the year 2019.
In respect of the same fact.
In respect of the same fact.
Yeah.
That is why I am placing that the judgment which was passed by the learned single judge, that can be can be upheld, lordship. Because that second marriage was not at all proved with the cogent evidence.
No, but is it within the scope of judicial review to re-examine the findings of the inquiry officer?
But that is the scope. That I admitted the fact that there is no judicial scope. But before the appellate authority, my lord, if my lord can see the order of the appellate authority, it is a mirror effect of the disciplinary order of the disciplinary authority. Even appellate authority also did not take care of the appeal of the delinquent. It is absolutely a mirror effect of the order of the disciplinary authority. There is even appellate authority does not apply their mind. So where can I go?
Appeal is an empty formality. That is what you are saying.
I bow down, your lord.
Yes. That is your submission.
Yes, lord.
We don't know what we will do.
You see, Kali come to my reply, my lord, before the writ petition, my lord. Some point which learned friend pointed out that Eloshi Kali come to my lord, page 136.
Yes.
That is volume 2, para 12. With reference to the statement made in paragraph 11 of this writ petition, I deny dispute all the allegations contained thereon, save and accept what are matters of record. I say that the contention made in the paragraph absolutely baseless, not admitted. As per procedure, preliminary inquiry was conducted against the complaint submitted by Srimati Pusha Devi, first wife of the petitioner. As per preliminary inquiry report, Constable Jitendra Jadhav committed an offence under acted in disciplined manner in violation of Rule 146, 144 RPF Rules 1987 and Rule 313 and 6 and then 21(2) of the Railway Service Conduct Rules 1992. 6. After outcome of the preliminary inquiry report, the petitioner was issued show cause notice to why the disciplinary proceeding under Rule 153 of the RPF Rules 1987 will not be initiated against him for illegal second marriage. On receipt of show cause notice, petitioner should have submitted reply of show cause notice to the competent authority, but he did not submit anything, madam. That is the important point, madam.
That is important.
Important
After charge memo, how it is important?
Then, madam,
Once a charge memo has been issued, where is the question of what happened prior to at the pre-charge memo stage?
Next paragraph, since no reply as well as written statement of defense against the show cause notice has been received from Constable Jitendra Jadhav, the Disciplinary Authority Assistant Security Commissioner, Metro, issued a memorandum of charge.
Why he issued? He should have issued an order of punishment. What are you arguing, sir? Yes.
Because, Malak, no reply has been.
That is a different thing. That's a pre-charge memo stage.
This is also, Malak.
That is a fact-finding inquiry to ascertain whether charge memo is to be issued or not.
Yes.
If they are of the opinion that there is nothing worth issuing a charge memo, at that stage they may not issue. If they find that there is some material, they may issue a charge memo. He has not replied at that stage, then they should have passed the order of punishment.
Objection pointed out before division bench, that is not.
What is the relevance of this submission that we are trying to understand?
Grievances.
Based on that, he can be punished.
Yes, but.
Oh, very well. Show us any judgment.
No.
Show us the law.
No. The law is clearly said that if your conduct is bad.
Where your conduct is bad?
Service.
Where your conduct is bad? In the service.
Because, Malad, after filing the inquiry report, after filing the preliminary inquiry.
No, now you are jumping to after filing the inquiry report. You are at the preliminary report.
But no objection has been taken out on.
So what? What is the consequence? Show us the service rule. Show us the service rule that if no reply is filed, then that will be presumed that he is guilty.
Not guilty, but
what you are arguing? You don't know.
Absence of objection, Malad.
What is the relevance? You can say everything. What is the relevance?
I am denying this at the point of division bench as well as single bench. That may be pointed out before the authority, competent authority.
If at the pre-charge memo stage.
Not pre-charge memo.
Yes, you are talking about pre-charge memo stage. That's a preliminary inquiry. Then charge memo is issued after that. Irrelevant argument you are doing.
The disciplinary proceeding were conducted by nominating.
Then you say I have argued so many times. This is what you argue repeatedly. Say something which is of any relevance. You are not here to just keep saying something after
just I assist you.
This is not an assistance. This is not an assistance. This is a.
To say, Malad, I am saying that previously that is the okay.
Don't raise such issues. We are asked. We have taken note. He was given a show cause notice prior to charge memo. He did not respond. Then why you issued a charge memo? You should have punished him. Why you didn't punish him? There's no relevance. It hardly means anything at the fact-finding inquiry. He may not. He will choose to say nothing. He will preserve everything to say in the after the charge memo is issued. If I were his lawyer, I would also advise him. Don't say
it. Malad, as per this case is concerned, only say that marriage as well as
that what you have argued, you have already argued.
Yes.
This is an irrelevant fact. It means nothing. It is neither here nor there.
আমাকে পাঠিয়ে দাও।
21.
Every results.
Yes.
Appearing for the authority is a very difficult job. I have heard that my lord was appearing for the authorities in your lordship days. It was not only to fight with the other side, you have to fight with your client, own client. Like the present one, a person was dismissed from service on the ground of the proceeding initiated that the loan sanctioned by him was not in accordance with. Honorable Single Judge relied on a note of CBC guidelines saying that you cannot charge him after two consecutive audit. You cannot charge. My first submission, I will started the matter before my lord. I say that the CBC guideline can overreach my lord, the statutory rules framed under the constitution by the service books. Now, after going through the my lord record, I found that this is a product of fraud. The my lord guideline, it said everything will be clear if it is fraud. It appears to me, my lord, in 2000, I will not trouble your lordship today. This is subsequent discoveries I want to bring on record. It appears that in 2008, fraud was detected of the loan sanction. And after detection of fraud, a so-called notice was given in 2008 and 9, and then 2010, disciplinary proceeding initiated. I will be praying before my lord to bring this on records under order 41 rule 27 because before the honorable single judge, this case was not at all made out. Because I was doing my lord injustice to my client. When I come to my notice.
So you want to submit that this fraud will.
Yes, he says that even if it is applicable, applies in the case, the fraud recedes everything.
And this forms the basis of the action.
Action. I want to bring not only the form, the action, the how he has proceeded. That record has to be.
You filed a opposition before the honorable single judge.
And it was not disclosed.
No, you filed an opposition.
I will be trying to bring it on order 1427 because in spite of due diligence, I could not get it. But according to me, my lord, subject to my lord confirmation, that this go to the root of the matter.
That will consider after you file.
This is my contention.
The learned senior advocate for the. This is just 3 weeks. When is the next date?
August.
Monthly list of August.
Monthly list of August, it will supposed to come.
So if there is anything happens, you come. Nothing will happen.
That's a lot.
It is only in the monthly list.
Yes, yes.
This way they may expedite filing of the application. Otherwise, they will sit tight over there.
My lord, problem is with the authorities matters, my lord. This is the problem.
Yes.
How I got these records, my lord, I know.
But apart from these points, but there are some other points. All these points were taken into consideration by the honorable single.
Must have been. We'll see. He's just filing. We don't know what we'll do.
He cannot prejudge now. I will filing it. Let us come.
You will file your reply. We'll consider.
Great.
22.
This is my appeal on behalf of the cantonment board, President Cantonment.
I appeal for the writ petition of respondent.
On behalf of the Cantonment Board
Yes,
and Union of India is respondent.
no, I am
Pro forma.
pro forma. Union of India is pro
Former
forma.
respondent. No, at the cause title, we are seeing Union of India.
Well, so Union of India is the pro forma.
Yes, yes,
respondent.
yes.
The main order is, this was a doctor in the Cantonment Board who was dismissed in exercise of powers which is akin to Article 3112B, summarily dismissed due to reasons stated in the order. Now, the court has held that in spite of existence of that provision and the power to dismiss summarily, I am bound to give them opportunity of hearing, and has set aside the order and the appellate order, and has directed that the proceeding be initiated de novo. De novo means from the charge sheet.
Proceeding be initiated.
Proceeding be initiated, madam.
Yes.
Proceeding be initiated. Well, my whole reliance is on Tulsiram Patel, which takes cognizance of Article 3112B, and has said, specifically that there are certain laid down guidelines, 3 guidelines. If those are satisfied, then there is no violation of natural justice. That apart, in the Act, there is already an provision for review, which has not been resorted to. I'll come to that afterwards. Kindly first.
Act as submission. Lordship, I have one submission. Lordship, there is a section 5, Lordship, let it be allowed. Lordship, I have a leader, Lordship, let the stay be fixed for hearing. And Lordship, all the documents which were there before the learned single judge are not enclosed in the
That
stay
I can
application.
file paper. Well, I was going into the merits because I am praying for stay of the order. There is a contempt petition pending on.
You do it, he will not proceed. In the meantime, they will not proceed.
Lordship fixes any day next week, hears out the stay application.
If your lordship wants to hear
How many days?
To place those also additional documents which are not placed, because that is the only additional, no other. The annexures, the impugn order has various annexures.
What is the nature of allegation?
Multifarious, multifarious. Private practice, manipulation, everything possible. That was the reason why they said that the.
But see, when the court has not gone into the substance of allegations, what is the point in having all that? Whether the procedure could be invoked under that provision or not, that is the only thing.
Very well. If required, subsequently,
We'll see,
if required,
yes.
I will bring those.
Yes.
Yes.
2023.
Yes.
But this relates to, my lord, initiation of proceedings against an employee post his retirement because of certain financial irregularities, my lord, which he had committed. Now, my lord, the challenge was basically, my lord, on this ground itself, my lord, where he has succeeded. The petitioner has succeeded, saying the learned judge, my lord, quashed the entire disciplinary proceedings, including, my lord, the punishment was that his half of his pension was not being recovered. That order has quashed. The order has quashed, my lord, the finding of the inquiry officer and, my lord, the disciplinary authority. This is the appeal is, my lord, against such. Lord, before I take your lordships through the impugned judgment, may I just give your lordship the brief facts?
Yes.
Lord, this gentleman, the respondent, writ petitioner, he was, my lord, the manager of the Central Bank of India College Street branch. Now, my lord, he superannuated on 31st of December 2004. Sorry. Now, my lord, the bank, Lord, on the basis of certain information, conducted a vigilance inquiry in this particular branch, where, Lord, the vigilance report said, Lord, about certain transactions, where, Lord, they found certain irregularities in these transactions. Lord, this vigilance report is dated 10th March 2005. Now, Lord, if your lordships kindly, Lord, comes to page 25 of the stay petition. Lord, this is the forwarding letter. The report is, Lord, next page, page 26. Lord, if your lordships, Lord, kindly have a look at the heading irregularities. Says, I've been advised by a general manager, Vigilant Department, to check the College Street branch under RO Kolkata at random with special focus on the following accounts. Then these 7 accounts. Besides this, reasons for leaving the bank by customers like so and so, famous Hajanta Hawaii Chappal, and working of the branch. Then, Lord, it gives, Lord, the details of certain loans which were sanctioned. Your lordships will kindly turn the page. Page 27, it was reported by some staff members and others related parties that so and so is a key person behind sanctioning of all loans. Brother-in-law of so and so and Mr. Hota was the broker between the bank and parties. All loans NPA, but not shown an NPA. Instructions stated to have been received from regional office. And Lord, these informations or irregularities were found in several accounts, which are, Lord, narrated. Kindly, Lord, come to the finding at page 31. Mr. Sunil Bhattacharya, ex-branch manager, Mr. S.N. Shaw, the then manager, had not followed the stipulated norms for sanctioning of advances during their tenure. All the above 7 CCOD TL accounts became NPA. Interestingly, NPA accounts were shown as PA, and Mr. S.N. Shaw was got promotion and presently posted at senior manager, Kalambag Road branch under Muzaffarpur zone. Mr. S.K. Bhattacharya retired from bank service on such and such. Then, Lord, these are the findings which are given. And the suggestions, Lord, are at page 33. Now, Lord, based on this, a show cause notice was issued. Yes. Lord, based on this, Lord, a show cause notice was issued on 24th June 2005. This is, Lord, from page 34 to 39. The reply to the show cause basically, Lord, it said that the capability of the borrower to repay was not thoroughly looked into.
So non-observance of lending formalities and norms.
Non-compliance with the lending formalities and norms.
But no, but it does not attribute any motive.
Lord, because I tell your Lordship, at that stage, if your Lordship looks at the suggestion, there was, Lord, a departmental inquiry was all suggested and
That we have
also
seen.
suggested an
Audit also.
Audit also.
That's why we are saying.
Audit
There's no attribution of any motive till now. Yes.
Then, Lord, your Lordship, except for the negligence, when the proceedings.
So non-observance, they say this vigilance team went, talked to those people. They said it was done when he was branch manager, and Mr. Shaw has also participated in the processing. Based on that basis, suggestion was made, proceeding, audit, and things like that. Then this was.
And Lord, those 7 accounts, Lord, loans were granted. All 7 accounts became NPA.
Yes, that is the whole basis.
That is the whole basis. And Lord, one big customer of the bank, he had shifted his accounts. So that was the other allegation. So, Lord, your Lordships will kindly see the reply which was given on 3rd August 2005. The reply came, which is at page 40. It was a mere denial. Now, Lord, at this stage,
yes.
At this stage, Lord, a writ petition was filed by the petitioner, Lord, which got disposed of by an order dated 8th of November 2006, which is at page 47 and 48. Lord, the gist of the grievance was that his retirement dues were not being released.
Yes.
The court directed, Lord, to dispose of the representation of the petitioner by the chairman and managing director of the bank.
What is the date of this order?
8th of November 2006. 2005, sorry. Now, Lord, the order of the chairman is at page 47 and 48. Lord, paragraph 9, if your Lordships kindly.
Yes.
Lord, his gratuity was released and the pension amount, gratuity and pension both were released. Subject to the bank's right to proceed against him in respect of the lapses misconduct.
The service rule permits.
Lord, I'll come to the service rule. That's the controversy. Because learned judge held that the service rule did not permit. That's the short point. I just give the facts and straight away come to the rules. Lord, after this, there was a charge sheet issued. Charge sheet is dated 23rd of February, page 49. 14/23rd of February, sorry, 2006.
2009.
2006. After the order of the chairman, the order of the chairman is 21st February.
Yes.
And this is not on 23rd of February.
At which page?
This is at page 49 to 55. The imputations are at pages 52 to 55.
So it must be all those 7 accounts.
They're same, absolutely. These are restricted to those. Then Lord, inquiry officer was appointed. Then Lord, reply to the charge sheet was given. That is at page 56 to 58. Lord, here, Lord, basically, again, Lord, denial, and Lord, he has challenged the initiation of proceedings. Second paragraph at page 56, if your lordship takes note of.
Oh, so this objection he has taken.
He has taken that objection. Then, Lord, page 59 to 65, Lord, inquiry proceedings were held 17th May 2006 to 12th July 2006. Between 17th May 2006 to 12th of July 2006, inquiry proceedings were held. These are at pages 59 to 65.
And he appeared?
No, he did not. And Lord, the inquiry officer, Lord, adjourned the hearings initially and ultimately proceeded to decide the matter ex parte.
What is the last day of the inquiry?
Last day of the inquiry is 12th of July 2006. This your lordships will get at page 65. Sorry, 63 to 65.
Yes, we have it.
Now, Lord, after this, inquiry report was submitted. And Lord, final order of the disciplinary authority is at page 66 to 69. Lord, the findings, your lordships will kindly, Lord, on the charges starts at page 66. And ultimately, Lord, half of his pension basically, Lord, the irregularities were established. It also established that in charge number 1, he had, Lord, allowed loan beyond his jurisdiction. Now, my lord,
Yes.
one of the controversy is with the writ petition was because, my lord, the writ petition filed in 2017. So after 10 years. This final order was passed on 19th March 2007. The writ petition was filed on 20th of March 2017. So, my lord, one of the contention that was raised by the bank is that there is inordinate delay insofar as writ petition is concerned, and therefore it should not be entertained. This is one issue that the learned judge has not answered. I'll address your lordship on this. But, my lord, to buttress this point, may I show one document at page 169 as to the date of knowledge of this order. 169 perhaps will be in the second point.
Once half pension goes, he will be knowing. If half the pension is gone, then he will be knowing anyway.
Lord, the issue is, one is power to initiate. Of course,
that we are saying about knowledge. Once the order was passed in March 2007,
yes,
then from April the pension must have become half. So he can't say he didn't have knowledge.
Absolutely. Absolutely. And Lord, he has issued this letter, his advocate has issued this letter, which is at page 169, where, Lord, it is acknowledged. This fact is acknowledged in 2010.
So at least a very clear acknowledgement in 2010.
He has come to know of it from 2007 itself because, Lord, there is a reflection in his pension account.
Must be, yes.
And this is what is, Lord, stated in page 171. If your lordships kindly come to page 71, kindly see the third paragraph that my client stated. Has your lordship got that?
Yes.
Submitted that he visited your Regent Park branch, Kolkata, for the updation of his passbook. It appeared from the passbook that to the tune of so and so was credited, an amount of so and so was fixed as pension amount. My client was never submitted by bank any calculation of pension chart. It appears from your letter that you have carried out one impugned disciplinary proceedings and passed an ex parte order to that effect at hot haste. You have got approved at your board's meeting dated 17th February 2007 adversely, arbitrarily, whimsically, and with malafide intention. Your actions are highly illegal as it appeared from your findings to that effect that you could not make out any prima facie case and that you have unlawfully, perversely withheld the pension payment to the tune of 50% of basic pension. So, my lord, 18th of March 2010, the immediate effect of the deduction of pension is also an admitted fact in this letter. Now, my lord, insofar as the writ petition is concerned, this was, I'm sorry.
Yes, please. Yes.
The writ petition was filed on 20th of March 2017. Now, Lord, in the writ petition, which starts at page 84, kindly, my lord, come to page 91, paragraph 15. The respondent bank, by a communication dated 21st August, I'm so sorry, page 91.
Yes.
Paragraph 15. The respondent bank, by a communication dated 21st August 2008, informed your petitioner that the reduction in pension was due to implementation of a purported approval order of the Board of Bank held on 17th February 2007. whereby punishment had been decided to be inflicted of your petitioner by reducing 50% pension amount permanently from the date of retirement. Surprisingly, from the said communication, your petitioner came to know that the bank had proceeded against your petitioner ex parte in the purported disciplinary proceeding. However, no copy of the daily proceedings, deposition of witness, materials that have been used by the bank in connection with the disciplinary proceedings, copy of the inquiry report shows cause notice has ever been supplied to a petitioner. This is of course, Lord, he takes. But Lord, the fact remains that in 2008, going by this paragraph, in 2008, at least he has come to know about the order and the affectation of his right. So, Lord, this was the first point which was raised that, Lord, after considerable length of time, this writ petition was filed as a second thought. Now, Lord, if your lordship now comes to the impugned order. My lord can look at it from the memo of appeal, if that is convenient. Otherwise, Lord, the that is also there. I'll give your lordship the page. It is page 277.
Paragraph?
Page 277 of the second volume, the order starts. Otherwise, your lordship.
Can you give the internal page of the?
Yes. I'll read it from the memo of appeal.
If it is convenient, let's.
Yes, it is absolute. Lord, kindly Lord, the court records, Lord, the facts. Kindly, Lord, come to paragraph 39, internal page 29. May I place para 39 onwards, Lord?
Yes.
The writ petition raises a pivotal legal issue in service jurisprudence, whether the Central Bank of India, in absence of proceedings instituted against the petitioner being a retired officer after his superannuation. The petitioner retired from service indisputably without any disciplinary proceedings pending against him on the date of his retirement. However, a charge sheet was issued against him in the year 2006, whereby the respondent bank sought to initiate departmental proceedings for certain acts as elucidated above, claiming the same to have occurred during his service tenure. The petitioner has assailed the disciplinary action on the grounds that once an officer retires, new disciplinary proceeding cannot be instituted against him, since relationship of employer-employee ceases to have be effective. The disciplinary framework under the Central Bank of India Officer Service Regulation is unequivocal. Then Regulation 44, it should kindly read it as Regulation 44. Conviction by court. Then 45, pensioners guilty of grave misconduct. Then 48. Rule 48 contained in, it should be regulation, General Conditions, Chapter 9, Central Bank of India Employees Pension Regulation 1995, stated as follows. Recovery of pecuniary loss caused to the bank. The competent authority may withhold or withdraw a pension or part thereof, whether permanently or for a specified period, an order recovery from pension of the whole or part of any pecuniary loss caused to the bank if in any departmental or judicial proceedings the pensioner is found guilty of grave misconduct or negligence or criminal breach of trust or forgery or acts done fraudulently during the period of his service. Provided that both shall be consulted before any final orders are passed. Provided further that the departmental proceedings, if instituted while the employee was in service, shall after the retirement of the employee be deemed to be the proceedings under these regulations and shall be continued and conducted by the authority by which they were commenced in the same manner as if the employee had continued in service. Provided also that no departmental or judicial proceedings, if not initiated while the employee was in service, shall be instituted in respect of a cause of action which arose or in respect of an event which took place more than 4 years before such institution. So this is the proviso, my lord, which has been relied upon by the bank for the purpose of initiating, because, my lord, it was within 4 years from his date of retirement.
No, not from the date of retirement, from the date of allegation.
From kindly see, provided also that no departmental judicial proceedings, if not initiated while employee was in service, shall be instituted in respect of a cause of action which arose in respect of an event which took place more than
Yes, the
4
event
years
has-
before such institution.
The event has to be
But
within
not
4
here,
years.
here, the detection of the event was not post his retirement in 2025, 10th March 2025. That is because, Lord, the accounts were not shown as NPA. As on date of his retirement, these accounts were not shown as NPA, although they were actually NPA. And that is the finding, Lord, of the vigilance report. In the vigilance report, your lordships will find the account became NPA, but they were not shown as NPA. So, Lord, the red flag, which is to be posted in respect of these accounts, were not posted. And that is why, Lord, it was detected on 10th of March 2005. Now, Lord, when it was detected in 2005, immediately the show cause notice were given and initiation of proceedings is, Lord, within a period of 4 years.
And he was posted in that branch during which period?
Period 2002 to 2004 until his retirement for a period of 2 years. He retired, Lord, on 31st of December 2004 as the manager of this branch.
Oh, that was his last posting.
That was his last posting. That was his last posting. He retired on that date.
And so the events come within 4 years, or you are trying to say that because the cause of action arose from the date of knowledge?
Yes. Cause of action.
Otherwise, the event does not come within 4 years.
4 years. But, Lord, the cause of action arose, Lord, within a period of 4
No,
years.
factually, we are just asking.
Yes.
Otherwise, the event does not come within 4 years.
Lord, I really speaking, I have not tasted that because, Lord, he was there for 2 years. 2 years.
That is why we are asking.
2004.
Let us see.
Even if it happened, Lord, I don't know exactly the date of granting loan. What is the date of granting loan? Lord, I have proceeded on the basis that, Lord, because
No, the date of sanction is given in the vigilance report.
yes, sorry.
In the statement of the persons who were examined, one has said about 26/8/2002.
All Lord 2002, between 2002 and 2004. Exact. 2002, 2003, 25.
So anyway, there may be a chance that 1 or 2 may be beyond the 4-year period, but still you say it is only when we examine the issue that we could detect it.
Correct.
So it's not a question of lapse, it is a question of acquiring the knowledge.
Without that, Lord, we couldn't have come to that conclusion that there is some irregularity so far as the accounts estimate statements are concerned.
And there is no annual audit in the bank.
There is no, and there was annual audit in the bank. There was, but Lord, because these accounts were shown as a regular account, obviously, Lord, the auditor, Lord, went by the statements that is appearing in the accounts.
No, because in the suggestion made by the vigilance also they say about an audit. So even after his retirement, there was no audit.
Of course, that audit really showed that there was irregularity. That audit was not a statutory audit, but Lord, the additional audit for the purpose of having found these irregularities to find out, Lord, whether there are further irregularities in the account holders.
Yes.
They're more a caution audit than anything else. Now, my lord, if your lordships kindly come back to the order of the learned judge, how, my lord, regulation 48 is, my lord, interpreted. Kindly, my lord, come to paragraph 44, internal page 31. Hi. Regulation तो यहीं से है, हो गया तो. Crucially, these provisions do not contemplate nor do they confer any power to initiate fresh proceedings against an officer after retirement except on specific provisions as mentioned in Rule 48(2) of the Central Bank of India Employees Pension Regulation. Evidently, the relationship of an employer-employee had been severed on account of superannuation, which had been a predominant condition incapable of artificially prolonged to institute a disciplinary proceedings against a superannuated employee except under specific statutory provision. In this context, Regulation 22 of the Central Bank of India Pension Regulation assumes significance. This regulation provides for forfeiture of pension in cases where an employee is dismissed, removed, or resigned in lieu thereof. However, it does not expressly grant the bank the validity to institute new disciplinary proceedings post-retirement. It merely prescribes the consequences of loss of service benefit when termination is on ground of misconduct. The distinction between jurisdiction to discipline and power to forfeit pension is foundational. The former pertains to control over the conduct of an employee. The latter relates to financial consequences only after lawful disciplinary action has been accomplished. Then, Lord, there is a Supreme Court judgment which is considered by Her Ladyship. Then, Lord, 48, 49, Lord, I skip because these judgments are extensively set out. Then, Lord, please come to paragraph 28 at page 36.
This is still the quotation.
Yes. At paragraph 28 is not, oh, sorry. Yes. Paragraph 50, I'm sorry. Kindly come to page 37. The articles of charge as enumerated above delineated explicitly and vividly the lapses committed by the petitioner in his official capacity by sanctioning overdraft limit to certain individual agencies, violating the guidelines for sanctioning of such loans, contravening the statutory provisions, exposing the banks to unnecessary risk. It was further alleged in charge number 1 that the petitioner failed to detect the following. Then, Lord, then the charges are discussed. Paragraph 55 talks about the reply. Then 56, the disciplinary committee has to, no, these are all, Lord, I think, these are all, please come to paragraph 59. The nature of lapses described in the article of charge cannot be exclusively attributable to the petitioner discharging his function in a supervisory category. The groundwork or the fieldwork was definitely not conducted by the petitioner functioning as senior manager of the bank. It should have been a teamwork with the report submitted by persons engaged in clerical posts as also outsourced persons who were responsible for collection of data and necessary information regarding the identity of individual loanees vis-a-vis the capacity to reimburse the loan. The articles of charge cited the lapses resulting in NPA without determining the exact financial loss sustained by the respondent bank. Moreover, the articles of charge did not explicitly mention the petitioner to have wrongfully gained consequentially. The specific provisions of Rule 48 cannot be resorted to with malafide arbitrariness, treating the lapses on the part of the petitioner to fall within exception of 4 years in the instant case where the respondent bank failed to ascertain the constituents and effect of NPA within 90 days. The unascertained loss accrued to the bank, moreover, in view of the judgment of Honorable Apex Court, so and so, wherein it had been in essence prescribed that disciplinary proceedings initiated against a retired employee was void ab initio. And on that ground, it says High Court cannot reappreciate evidence and usurp the role of trial court, however, can definitely interfere to address an act which is harassing, arbitrary, and motivated. In view of the above discussion, this court finds that the articles of charge dated such and such and all consequential actions are unsustainable law and accordingly quashed. Now, my lord, in so far as the delay aspect is concerned, your lordships will find the court has not, lord, addressed the delay aspect at all. Though kindly come back to page 4, your lordships will find when the submissions were recorded, page 4, last line. The petitioner had challenged the order in 2017, 10 years later. जजमेंट नहीं तो फिर कैसे जजमेंट दिखाएंगे? Lord, just 2 points. One is delay, complete delay, Lord, in Lord filing the writ petition for 10 years. After knowing that there is an order passed, his pension was reduced to half. He, Lord, sat tight. He did not challenge the matter. Therefore, Lord, the writ petition ought to have been dismissed on the ground of delay alone. The secondly, although the learned judge says that 48(2) permits initiation of proceedings if initiated within a period of 4 years post-retirement. But Lord, she feels that these are collective liabilities which had to be looked into, number one. Number two, she says that the actual loss suffered by the bank has not been established. This is the finding in paragraph 59. Now, Lord, what happens is once the account is declared as NPA, bank will have to initiate proceedings for the purpose of, Lord, recovery, and then only, Lord, the actual loss can be ascertained, which comes at a later date. But Lord, an NPA account, where, Lord, the capability of the borrower is itself questioned, your lordships can well imagine, Lord, how the proceedings have proceeded. And in any event, he should have been more alert. He should have come to court, Lord, within two years or whatever. Then, Lord, all these proceedings, Lord, could be brought to the notice of the court that this is the recovery proceedings, this is the stage the bank is, whatever the recovery has happened or not happened. All these questions could have been brought in. After 10 years, many things have flown through the Ganges. Lord, in fact, when he came, he did not have a right to sue, as on the date, Lord, when he came. Lord, on the delay, Lord, I don't want to cite judgments, multiple judgments on this, but Lord, it is well settled principles that, Lord, the Limitation Act 3 years applies, and Lord, the delay, normally delay beyond 3 years is not condoned by the court. This is a well established principle. Unfortunately, Lord, the copies of the judgments are not here, but this is the basic principle. I don't want to dilate on that. And on the right to initiate proceedings, it's the regulation 48, regulation 2 that provides so. These are the two provisions on which, Lord, these are my submissions.
Yes.
This vigilance report note I indicated on the last date was not part of the records.
So sorry, I didn't know that. I was not there in the trial. I first were there.
In fact, I indicated, not that's not part of.
It didn't reach me. I'm so sorry. Otherwise, we would have.
He also didn't remember.
No, when we say that all the records, all the documents are on record.
Mr. Majumdar should have indicated that I could have filed an application under Order 41, Rule 27.
But it fell from the bench in any way. This is not going to turn out in this. It's a staff accountability report, something like that. Anyway, I proceed on that.
I'm really sorry, but I did not know. Otherwise, I would have been the first person to.
Please come to paragraph 29 of the judgment. At pages 90 and 91 of the stay application, which is part of the pleading. Please come to page 90 first. That's part of my writ petition.
Paragraph 29.
Page 90 of the stay application. in volume 1. Paragraph 13, it says that even at that stage and after passing of the order of 21st February 2006 by the chairman and managing director of the bank, your petitioner had not been allowed to commute his pension from January 2005. However, on or about 28th April 2007, your petitioner's bank account had been unknowingly credited by an unaccounted amount of rupees 1,87,322. On query from the branch of his last posting, came to know that the said amount represented the pension valuable from the bank during the period from January 2005 to March 2007, that is 27 months, and also an amount of rupees 7729 being the pension for the month of April 2007. However, no statement or chart had been given to your petitioner detailing the basis of such payment. Your petitioner states that on his estimation, should be something, a word is missing, a sum of rupees 3,51,000 was payable, more or less, was payable to him towards the arrear pension of 27 months as aforesaid, and your petitioner was further entitled to a commutation of 1/3 pension, which would have been 3,25,000 rupees, more or less. Furthermore, your petitioner's monthly pension would have been rupees 14,000 more or less, and not 7,729 as credited by the bank. Your petitioner therefore made a representation on 10 June 2007, claiming the commuted value of pension, the correct amount of arrear pension, as also the interest on gratuity, apart from the correct monthly pension. But he made a representation. Up to 2008, there are representations. The respondent bank, by a communication of 21st August 2008, informed the petitioner that the reduction in pension was due to implementation of a purported approval order of the board of the bank held on 17th February 2007, whereby punishment had been decided to be inflicted on your petitioner by reducing 50% pension amount permanently from the date of retirement. Surprisingly, from the said communication dated 21st August 2008, your petitioner came to know that the bank had proceeded against your petitioner ex parte in the purported departmental proceeding, disciplinary proceeding. However, no copy of the proceedings, deposition and materials that might have been used by the bank in connection with the inquiry, copy of the inquiry report, show cause notice had ever been supplied to your petitioner. Till today, your petitioner has also not been communicated of the penalty order imposed or decision taken by the disciplinary authority who initiated the disciplinary action. A copy of the communication of 2008 is annexed. Your petitioner states that the disciplinary proceeding was initiated against him by issuance of charge sheet through the pen of the Assistant General Manager and the disciplinary authority respectively. In terms of the service regulations pertaining to the disciplinary action of your petitioner, the board of directors was the affiliated authority, and as such, the said board could not have exercised jurisdiction to impose punishment on the petitioner so as to deprive him of the opportunity to prefer a departmental appeal. The communication of 21st August 2008 is therefore a disclosure of high-handed, illegal and extended. I don't detain your lordship not on the allegations on the attack on those communication. Now, please come to 2009, the next page, 1990, page 93. The bank, by letter dated 19th March 2009, reiterated its stand and gave a breakup of a credited amount of 1,87,322, wherefrom it is clear that the bank had imposed the punishment in the matter of curtailing the pensionary benefit of your petitioner. Copy enclosed. Your petitioner had therefore after made several representations from 2010 to 2016, either himself or through his lawyer, claiming the reliefs of full pensionary benefits, representations annexed. Then the association also made representation. One of the representations is of 15th March 2013, wherefrom it is clear that the bank has no record of findings of the inquiry served on your petitioner, and likewise there is also no record of service of final order on your petitioner. Copies of representations enclosed. Your petitioner states that the pensionary benefits have been reduced in purported exercise of its power to recover pecuniary loss caused to the bank in terms of regulation 48 of the pension regulations. So that is the enabling provision which the bank wants to place reliance upon. The general conditions relating to pension payable in terms of pension regulations 1995 as contained in chapter 9, but I shall rely on those regulations. Petitioner states that in terms of regulation 46, your petitioner was entitled to provisional pension in the event that I skip over this provisional pension, then Rule 9 and Rule 20 of the Central Bank of India Officers Discipline and Appeal Regulations. It is incumbent on the bank to communicate orders and serve the same on the officer employee concerned. Copies of the rule enclosed. In your petitioner on or about 13th of February 2017 has downloaded from the bank's official website the provisions relating to conduct of an institution of disciplinary proceeding, wherefrom it has come to revelation that the bank had introduced the same in 1998. The said document also discloses various administrative circulars and clarification regarding various service conditions of the officer employees. Your petitioner was undoubtedly an officer of the bank during his superannuation from the bank service. It is apparent that Regulation 20 Sub-Regulation 3 was introduced in the appeal regulations in 1998. There are administrative clarifications under Regulation 20 as uploaded in the website requiring fulfillment of certain obligations on the part of the bank before withholding retirement dues. Regulation 20 Sub-Regulation 3 of the Discipline and Appeal Regulations therefore require a conscious application of mind to withhold retirement dues, and the said amended provision purports to only cover cases where disciplinary action had been initiated prior to superannuation of an officer employee of the bank. Then juxtaposition of Regulation 46 and 48 of the Pension Regulations and Regulation 23 of the Discipline and Appeal Regulations would lead to the only possible inference that the bank does not retain any jurisdiction to initiate disciplinary action against an officer employee who has superannuated from the service of the bank. Not this, your lordship will have to interpret. In the matter of initiation and conduct of disciplinary action, the Discipline and Appeal Regulations is a special provision vis-a-vis the pension regulations, and as such the enabling provision contained in the statutory regulation on a later date was made obviously being conscious of the earlier provisions contained in the Regulation 46 of the Pension Regulations 1995. Then says that your petitioner had never been served with any communication or order towards withholding of retirement dues in terms of Regulation 23 of the Discipline and Appeal Regulations during his service tenure or at the time of his superannuation. In any event, the respondents have acted wholly without jurisdiction in initiating the disciplinary action after your petitioner's superannuation from service. So, till 2017 and till that time, the order was not disclosed and there had been repeated representations. The response was the bank is not in possession of the records. So, after exploring all avenues, I had approached this court with a representation that please supply me a copy of the order at least so that I could take steps. Now, please come to paragraph 29 of the judgment under appeal. That's internal page 15.
That 23 was considered by the
Rule 23.
20 within bracket 3 that some circular.
Oh, that discipline and yes. Learned advocate representing the bank submitted that the disciplinary proceedings had been conducted strictly in accordance with the provisions of the Pension Regulations 1995, particularly Regulations 45 and 48, which expressly permit such proceedings and empower the competent authority to withhold pension wholly or in part in cases of proven misconduct. It was contended that the petitioner had full knowledge of the proceedings, having received the charge sheet and notice of hearing, but willfully abstained from participating. The findings in the inquiry revealed that the petitioner had sanctioned multiple high-value loans without due diligence, which had turned into NPAs and caused tangible loss to the bank. But I lay emphasis on these words. The respondents emphasized that under the RBI guidelines, such NPAs, especially those classified as quote-unquote loss assets, are to be fully written off, thereby establishing pecuniary loss. The bank urged that the penalty imposed was neither disproportionate nor illegal, given the nature of the misconduct and the fiduciary position held by the petitioner. Should I skip over the scope of judicial review and invite your lordship to come to paragraph 31. Now, this is the order by which my claim for release of retirement benefits was rejected by the managing director of the bank. But in reference to the caption, I place that order. In reference to the caption court's order, I have perused the bank's relevant records of the case, including the representations of the petitioner. My observations with regard to the same and the order are as under. Petitioner retired from the bank service on superannuation on 31st December 2004. He was paid his own contribution to the PF account on 18 January 2005. Since he is a pension optee, the bank's contribution to his PF account should transfer to the pension fund. After his retirement, certain lapses on the part of the petitioner committed in granting advances while working as the branch manager of the College Street branch came to light. The reported lapses are of the period June 2002 to September 2004. Investigations were carried out and it was reported that the lapses were of grave nature and hence the bank issued him a memo dated 24 June 2005 calling for his explanation with respect to the same. The petitioner filed the caption deed petition, copy whereof was not received by the bank, and the bank came to know of the order passed by the Honorable Court only when it was served by the petitioner on 17 December 2005. At the time of his retirement, he was entitled to be paid his gratuity dues as also pension, albeit subject to the bank's right to proceeding against him under the bank's pension regulations for his reported misconduct. In the light of the above, I pass the following order. The petitioner shall be paid his gratuity dues payable to him as per the bank's gratuity rules or the Payment of Gratuity Act, whichever would be applicable in his case. He shall also be paid the pension amount under the pension regulations, subject to the bank's right or proceeding against him in respect of the reported lapses or misconduct, and he shall be liable for the consequences thereof. Such dues shall be paid subject to the petitioner completing all formalities. The petitioner may be informed of the bank's above decision on his representations and this order may be served on him forthwith. Lastly, in view of the dues having been ordered to be paid as above, as advised, I dispensed with personal hearing to be given to the petitioner in the matter. The charge sheet issued by the disciplinary authority reads as follows. I need not trouble your lordship. So, as on 2006, the bank's decision was that I should be released all my retirement dues subject to departmental action. Now, please come to paragraph 37, where Rule 45 is quoted. The internal page 28. Rule number 45 contained in General Conditions Chapter 9 of Central Bank of India Employees Pension Regulation stated as follows. Pensioner guilty of grave misconduct. In a case not falling under Regulation 44, if the competent authority considers that the pensioner is prima facie guilty of misconduct, of grave misconduct, it shall, before passing an order, follow the procedure specified in Officers' Employees Discipline and Appeal Regulations or in settlement as the case may be. Rule number 48 reads as follows. Recovery of pecuniary loss caused to the bank. The competent authority may withhold or withdraw a pension or a part thereof, whether permanently or for a specified period, and order recovery from pension of the whole or part of any pecuniary loss caused to the bank. If in any departmental or judicial proceedings, the pensioner is found guilty of grave misconduct or negligence or criminal breach of trust or forgery or acts done fraudulently during the period of his service. So, the primary condition is ascertainment of pecuniary loss which can be recovered or suspended. Then the last proviso on that page is that enabling provision, provided also that no departmental or judicial proceedings, if not initiated while the employee was in service, shall be instituted in respect of a cause of action which arose in respect of an event which took place more than 4 years before such institution. Then paragraph 39 is the discussion. This writ petition raises a pivotal legal issue in service jurisprudence whether the Central Bank of India, in absence of proceedings instituted against the petitioner being a retired officer after his superannuation. Then regulation number, please come down to rule number 44. Rule 44 contained in general regulation, in pension regulation stated as follows. Where a pensioner is convicted of a serious crime by a court of law action shall be taken in the light of the judgment of the court relating to such conviction. Rule 45 reads as follows. But I have placed that Rule 45, which gives power to withhold. Rule number 48, I have already placed before your lordship. Now please come to the next page, paragraph 44. Crucially, these provisions do not contemplate nor do they confer any power to initiate fresh proceedings against an officer after retirement except on specific provisions as mentioned in Rule 48(2) of the Central Bank of India Pension Regulations. Evidently, the relationship of an employer-employee had been severed on the account of superannuation, which had been a predominant condition incapable of artificially prolonged to institute a disciplinary proceeding against a superannuated employee, except under specific statutory provisions. In this context, Regulation 22 of the Employees Pension Regulations assumes significance. This regulation provides for forfeiture of pension in cases where an employee is dismissed, removed, or resigns in lieu thereof. However, it does not expressly grant the bank the validity to institute new disciplinary proceedings post-retirement. It merely prescribes the consequences for loss of service benefits when the termination is on grounds of misconduct. The distinction between jurisdiction to discipline and power to forfeit pension is foundational. The former pertains to control over the conduct of an employee, the latter relates to financial consequences only after lawful disciplinary action has been accomplished. Then the Honorable Supreme Court in State Bank of India versus Naveen Kumar Sinha, this judgment is quoted. Please come to paragraph 26 of that quoted judgment. We are afraid we cannot accept such a contention on behalf of the appellants where the disciplinary proceeding itself is without jurisdiction, upholding the same on the specious plea that it was not challenged on the ground of lack of jurisdiction would be tantamounting to giving imprimatur to a patently illegal proceeding. This aspect was gone into by the learned single judge in the following manner. Let I skip over the quotation from the judgment. Your lordship may now straightway come to paragraph 59 and 60. I'm sorry, paragraph 56 and then 59, 60. Paragraph 56 is at 38. The disciplinary committee hastily concluded the proceedings, ex parte without granting further time to the petitioner to address the articles of charges framed against him. What prompted the disciplinary authority to expeditiously dispose of the proceedings, adverting the principles of natural justice, is unfathomable. The petitioner did not contribute towards his pension before opting for the pension scheme where the sole contribution was deposited by the respondent. The petitioner, upon being superannuated, had been deprived of his retirement benefits arbitrarily and surreptitiously in deception and in the disguise of a disciplinary proceedings. According to RBI guidelines of July 1, 2011, which defined NPA, it was incumbent upon the respondent bank to identify the assets as NPA on an ongoing process. Quote unquote, the system should ensure that identification of NPAs is done on an ongoing basis and doubts in asset classification due to any reason are settled through specified internal channels within 1 month from the date on which the account would have been classified as NPA as per prescribed norms. Banks should also make provisions for NPAs as at the end of each calendar quarter, that is, as at the end of March, June, September, December, so that the income and expenditure account for the respective quarters as well as the profits and loss account and balance sheet for the year end reflects the provisions made for NPAs. The nature of lapses described in the article of charges cannot be exclusively attributable to the petitioner discharging his functions in a supervisory category. The groundwork or the field work was definitely not conducted by the petitioner functioning as a senior manager of the branch of the bank. It should have been a teamwork with the report submitted by persons engaged in clerical posts as also outsourced persons who were responsible for collection of data and necessary information regarding the identity of individual loanee vis-a-vis the capacity to reimburse the loan. The articles of charge cited the lapses resulting in NPA without determining the exact financial loss sustained by the respondent bank. Moreover, the articles of charges did not explicitly mention the petitioner to have wrongfully gained consequentially. The specific provision under Rule 48 cannot be resorted to with malafide arbitrariness, treating the lapses on the part of the petitioner to fall within the exception of 4 years in the instant case, where the respondent bank failed to ascertain the constituents and effect of NPA within 90 days, the unascertained loss accrued to the bank. Moreover, in view of the judgment of the Apex Court in Naveen Kumar Sinha, wherein it had been held in essence prescribed that disciplinary proceedings initiated against a retired employee was void ab initio. High Court cannot reappraise evidence, need I skip over that paragraph. In view of the above discussions, this court finds that the articles of charge dated so and all consequential actions are unsustainable law and accordingly quashed. The respondents directed to release all pending retiral dues to the petitioner, including pension, gratuity, and leave encashment within 6 weeks from the date of communication of the order. Dues to be paid within 3 months from the communication of this order. Similar, two rules under the pension, two regulations under the pension regulations essentially fail for consideration. One, duty to withhold vis-a-vis the pension regulations and the discipline and appeal regulations. 20 sub-regulation 3 of the discipline and appeal regulations vis-a-vis regulation 44 of the not 44, withholding. Regulation 22, right to forfeit pension.
20 within bracket 3.
20 sub-regulation 3 of the service regulations. Read with regulation 22 of the pension regulations. Now, my lord, the service regulations were inducted through an amendment in 1998, as the court records. Regulation only 22 টা রয়েছে। My lord, the regulations have been annexed at page 194 in the second volume. But the chapter is general conditions. 42 says pension subject to future good conduct. No, we are not concerned with that. 43 is withholding or withdrawal of pension. The competent authority may by order in writing withhold or withdraw a pension or a part thereof, whether permanently or for a specified period, if the pensioner is convicted of a serious crime or criminal breach of trust or forgery, or acting fraudulently, or is found guilty of grave misconduct, provided that where a part of pension is withheld or withdrawn, the amount of such pension shall not be reduced below the minimum pension per mensem payable under these regulations. Comments. Withholding or withdrawal of pension. Pension can be withheld or withdrawn in all cases of grave comment. 44. Conviction by court. Where a pensioner is convicted of a serious crime by a court of law, action shall be taken in the light of the judgment of the court. Then please see the interplay of 43 and 45. 43 is withholding or withdrawal of pension. 45 is pensioner guilty of grave misconduct. In a case not falling under regulation 44, if the competent authority considers that the petitioner is prima facie guilty of grave misconduct, it shall, before passing an order, follow the procedure specified in Officer Employee Discipline and Appeal Regulations 1976 or in the settlement as the case may be. Now, now also consider not paragraph this regulation 48. Recovery of pecuniary loss caused to the bank. The competent authority may withhold or withdraw a pension or a part thereof, whether permanently or for a specified period, and order recovery from pension of the whole or part of any pecuniary loss caused to the bank. If in any departmental or judicial proceedings the petitioner is found guilty of grave misconduct or negligence or criminal breach of trust or forgery or acts done fraudulently during the period of his service. So this was referred to by the bank because the managing director had decided not to withhold pension by his own order of 2006. Provided that the board shall be consulted before any final orders are passed, provided further that the departmental proceedings, if instituted while the employee was in service, shall, after the retirement of the employee, be deemed to be proceedings under these regulations and shall be continued and concluded by the authority by which they were commenced in the same manner as if the employee had continued in service. Provided also that no departmental or judicial proceedings, if not instituted while the employee was in service, shall be instituted in respect of a cause of action which arose or in respect of an event which took place more than 4 years before such institution, where the competent authority orders recovery of pecuniary loss from the pension. The recovery shall not ordinarily be made at a rate exceeding 1/3 of the pension admissible on the date of retirement of the employee. Provided that where a part of pension is withheld or withdrawn, the amount of pension drawn by a pensioner shall not be less than the minimum pension payable under these regulations. Then recovery of bank's dues. The bank shall be entitled to recover the dues to the bank on account of housing loans, etc. So, in the instant case, the bank having chosen to invoke regulation 48 for the purpose of recovery,
That is under which regulation 49?
regulation 48. Because the bank itself said that I am not withholding the pension, you are entitled to the same from the date of your superannuation, subject to disciplinary proceeding. So once disciplinary proceeding kicks in, not all the provisions of regulation 48 have to be employed. Now regulation 48 can only operate in a field for the purpose of recovery of pension of an ascertained loss.
You want to continue?
But I have one copy. This is the only judgment I wanted to rely upon.
Then give us, you have one copy. Yes. Ask him to get another printout in the meantime.
It's 2016 SCC Online Calcutta 5205.
The point you are urging is unless the loss is quantified, there is no question of a recovery. That is what you are saying. And there is no quantification of the loss.
And but the bank itself decided to invoke regulation 48.
Okay, this is born from their conduct. At the time of my retirement, they decided to pay all the dues. They said this is subject to what we may do in the future. Now the recovery, and according to you, under 48 can only be of an ascertained or quantified loss. That not being done, it was not permissible.
But like not the regulations I find are alike, not the CCS pension regulations, CCS pension rules. Almost like that. Good conduct, future conduct, conviction, forfeiture.
Within 4 years.
Within 4 years. All provisions are alike the CCS pension rules, but not the bank itself having chosen to invoke 48 is stopped from invoking any other provision. But I read not from the marked not with the paragraph numbers, Lordship may kindly
give it, don't worry.
But this was a case where not the question came up for consideration before the coordinate bench of this honorable court. But please have a look at paragraphs 4 and 5, not first for, but it came in the context of gratuity claim. But the first question was whether Payment of Gratuity Act would have application or Regulation 46 of the UCO Bank's regulation, gratuity regulations would have application. When a writ petition was filed by the employee seeking a declaration that Rule 18 of the UCO Bank Employees Provident Fund Rules was ultra vires Section 10 of the Employees Provident Fund Act and Article 21 of the Constitution of India, the employee further sought a direction to the bank to release the bank's share of contribution of the Provident Fund along with the accrued interest thereon and the gratuity and leave salary together with interest on such of the amounts. The writ petition was decided on 29 March 2012 by the learned single judge of this court. It was found. Now it was towards Provident Fund and the interest on the delayed payment of the employee's share of Provident Fund was illegal. The court noted that the employee's claim for leave encashment was undisputed and therefore directed the bank to grant the benefit. As regards gratuity, the court held that the bank could not forfeit the same as the employee's services were not terminated either for willful omission or negligence causing financial loss to the bank or for an offence involving moral turpitude. Being agreed by the decision of the learned single judge, the bank has preferred the appeal. The first argument by the learned counsel on behalf of the bank was that gratuity is payable to the employees of the bank in terms of Regulation 46 of the Officer Service Regulations. According to him, Regulation 46 empowers the bank to forfeit the gratuity payable to the employee who has committed misconduct. Drawing our attention to Regulation 46, the learned counsel submitted that the bank is liable to pay gratuity only on retirement or death of an employee and in the case of a disablement which has rendered an employee or officer unfit for further service as reported by a medical officer approved by the bank. But I skip over not the statutory provisions. Please come to paragraph 8. Learned counsel appearing for the employee drew our attention to the provision.
Yes.
Learned counsel appearing for the employee drew our attention to the provisions of the Payment of Gratuity Act and pointed out that the Act is applicable to an establishment unless an exemption from the payment of gratuity under the Act has been granted by the appropriate government under Section 5. He pointed out that admittedly no such exemption had been granted to the bank and therefore the service regulations with respect to payment of gratuity were not applicable and it is Payment of Gratuity Act which governs the employees of the bank. He then submitted that when the order of removal was passed without quantifying the loss caused to the bank, it cannot hold any further inquiry to quantify the loss, as that would mean the employee would have to undergo a fresh inquiry, which is not contemplated in law. Then we're coming straightway to paragraph 15. Not the court considers not when gratuity is payable. Then in paragraph 16, the court holds the Payment of Gratuity Act does not have any provision for establishing a trust for disbursement of gratuity or for empowering the trustees of such a trust to decide whether gratuity should be paid to an employee. Subsection 6 of section 4 starts with a non-obstante clause and provides that gratuity must be paid to an employee whose services have been terminated. However, if the termination was for any act, willful omission or negligence which caused any damage or loss or destruction of the property belonging to the employer, the gratuity may be forfeited. The forfeiture of gratuity is permissible only to the extent of the damage or loss so caused. Thus, the employer is not bound to forfeit the gratuity in every case of loss or damage. In the present case, the charge sheet issued to the employee does not indicate or quantify the loss allegedly caused to the bank. The disciplinary inquiry was conducted on the basis of certain acts and omissions on the part of the employee, which the bank found were deliberate. The acts complained of were firstly, the court goes on to secondly, the employee had continued to permit overdrawing of amounts in various accounts despite receiving instructions to the contrary. It was again found to be violative of Section 3 of the aforesaid regulations of 1976. The third charge was that the employee had deliberately not reported irregularities to his superiors with an ulterior motive, which again constituted failure to discharge his duties with utmost integrity or devotion, which was in breach of Clause 3 of the aforesaid regulations. All these charges have been proved against the employee. However, not one of the charges mentions the actual loss caused to the bank. In fact, the charge is that the employee's acts indicate that he was guilty of having violated the provisions of Regulation 3 of the UCO Bank Officer Employees Conduct Regulations and not for having caused any loss to the bank. The disciplinary authority issued a show cause notice to the employee concerned before imposing the punishment. The loss caused to the bank was not mentioned even in this notice. Then paragraph 17. The contention that this denial of gratuity can be regularized by providing a fresh show cause notice to the employee at this stage, detailing the loss caused to the bank and asking for his explanation before denying the gratuity is, in our opinion, untenable. An employee cannot be subjected to two inquiries for the same acts of misconduct. The second inquiry is not envisaged in law. An employer cannot be permitted to keep holding inquiries in order to fix a liability on the employee. All allegations against the employee ought to have been mentioned in the charge sheet, which was issued to him before holding the disciplinary inquiry. Had the bank been able to assess the loss caused to it, it should have been mentioned in the charge sheet. Having omitted to do so, the bank cannot be afforded another chance to nail the employee and plug the lapses. If the bank was of the opinion that the loss could not be ascertained at that stage, as submitted, it could have mentioned so in the charge sheet. Even at the time of issuing the show cause notice to the employee, on submission of the inquiry report, the bank did not mention the loss. The bank's communication of 15 February 2010 only requires the employee to show cause why his gratuity should not be forfeited. It does not say anything about the actual loss caused to the bank. There was no bar on the bank when it issued the charge sheet or indeed the show cause notice before imposition of the punishment on mentioning the loss caused to it. The bank cannot be permitted to improve upon its case only in order to ensure that the gratuity is forfeited. Then, moreover, the submission that the show cause notice will be issued granting an opportunity to the employee to defend himself is also of no avail. The trustees of the gratuity fund who have issued the earlier show cause notice are not the employer of the respondent employee. But I skip over that aspect. Then the last sentence, a second inquiry to ensure the denial of gratuity is unacceptable. In our opinion, the learned single judge was right that the gratuity could not be denied to the employee. However, we do not agree with his finding that the gratuity is payable in terms of Regulation 46 of the Service Regulations. Then note 20, on the other hand, submitted that the trustees of the Provident Fund cannot deny payment of the employee's contribution when the loss has not been quantified. No, that is on a different aspect altogether. So the foundational basis of this judgment was unless loss is ascertained or mentioned in the charge sheet or even before imposition of the punishment, then not the power to withhold this gratuity amount, not similar provisions in this regulation cannot be allowed to be implemented. The first and foremost of 48 is if there is a loss caused to the bank. And the bank itself chose to invoke Regulation 48, so it's bound by it. These are my submissions.
Yes. Yes.
But on the service of the order, first, if your lordships please come to page 213. This is the affidavit in opposition filed by the bank.
But on the delay part, it's
You
right.
have said representations, they did not serve the order and all this.
That's one aspect. The second aspect is not right to pension is a continuing right. So far as arrears are concerned, this delay may defeat my right being restricted to 3 years of arrear pension. That's the consistent view of courts. In the nature of money claim, had it been a money claim, my right would have been restricted to the last 3 years. So arrears would be restricted to 3 years anterior to the date of institution of the writ petition at the most. But this will not defeat my right to get pension at a correct rate, not for all time to come.
Yes. Now, my lord, on the service of the order, if your lordships kindly come to page 213.
Yeah. Page
213. The affidavit in opposition, lord, starts at page 205.
Yes.
Kindly come to 213, subparagraph R. Should be paragraph 3R. In terms of the order, dated 19th March, the regional manager of the bank issued administrative order 27th March for withdrawal of 1/2 of the pension primarily as per regulation 48 of the regulation. A copy of the said order 19th March 2007 was sent to the petitioner through post as well as by hand, but the envelope sent through post was returned to the office of the respondent with postal remark not claimed. And the letter sent by hand was not also accepted by the petitioner. A copy of the returned envelope with postal remark is annexed. So, my lord, refusal to accept a letter. Consequences is it is served. It is deemed to have been served. So, my lord, coupled with this fact, the fact of deduction in his account, which took effect immediately, there is a deemed knowledge so far as he is concerned from 2007. And in the writ petition, there is no explanation why, my lord, it took him 10 years to move the court. So, my lord, if I succeed on the point of delay, that itself, lord, takes away his right to sue. On the other aspect of the matter, he says that no pecuniary loss was suffered by the bank or shown to have been suffered. Now, my lord, in so far as the NPA is concerned, declaration of NPA is concerned, it has a consequence in law. It's a non-performing, it becomes a non-performing assets based on certain Reserve Bank directions or circular issued from time to time. Clearly indicates that the account has become non-performing assets. But Lord, the proceedings have to be initiated, a decree has to be obtained. Now, Lord, when the departmental proceedings was initiated, because Lord, 4 years time we have to initiate the proceedings. We can't go beyond that. Gentleman had retired. The knowledge of these facts came post his retirement. So, Lord, initiation of proceedings happened at that stage. And thereafter, Lord, obviously, the proceedings, Lord, he did not participate. He did not take any defense with regard to suffering of loss. All these questions never was raised before the inquiry officer. Now, Lord, the issue today is, if your lordships kindly, Lord, have a look at Regulation 48 once again. I can give a copy of the regulation, Lord. That will be much easier.
Page 194.
190, yes. 194. If your lordships takes 194.
48 is at 196.
196, yes. 48, Lord, your lordship kindly have a look at 48. It says the competent authority may withhold or withdraw pension or part thereof, whether permanently or for a specified period, and order recovery from pension of the whole or part of any pecuniary loss caused to the bank, if any departmental or judicial proceedings, the pensioner is found guilty or grave misconduct or negligence or criminal breach of trust or forgery acts done fraudulently during the period of this service. Now, Lord, the pecuniary loss should be connected to the misconduct. And Lord, declaration of NPA, in my humble submission, is a clear establishment of a fact that, Lord, these accounts were not performing. And Lord, the cause of non-performance has been found out by a detailed inquiry. The findings are, Lord, certain loans are given to people who don't have capacity to repay. Now, Lord, if these findings are not, Lord, a prima facie finding of the loss, pecuniary loss that the bank is going to suffer. After all, Lord, these are public money, which are, Lord, there are established guidelines for granting of loan. If these the established guidelines are violated for the purpose of granting loan, and the account becomes NPA, obviously, Lord, there is a deemed, Lord, financial loss that the bank has. Only thing is the calculation. Actual loss that has been suffered over a period of time with interest, that will come out in the proceedings, which was initiated ultimately, Lord, the culmination of the proceedings. But Lord, point today is that, Lord, here is a case where, Lord, public money was, Lord, disbursed. And if your lordships kindly, Lord, take this vigilance report once.
There's no allegation of sanction without collateral or anything.
Yes, Lord, there is. If your lordship kindly come to page 52, kindly, Lord, have a look at the charge sheet once. First charge relates to exceeding his jurisdiction to lend 30 lakhs, for which he did not take sanction. Second charge, Lord, page 53. Lord, kindly see, it says low turnover and frequent returning of check, charge number 3.
So there is no allegation that collateral was not taken. It is non-observance of some norms or formalities. And this also charge has arisen because it has been declared an NPA.
All the accounts, Lord, surprisingly, whatever loan account was sanctioned, every account became
all these
NPA.
7 accounts became
all 7 accounts. And Lord, some of them, there is a finding that, Lord, the paying capacity of the borrower was not there. That was also not verified. That itself, Lord, should show. For example, charge number 5, it was house building loan.
Yes, it was an incomplete structure.
It became
on the date of sanction, it says that it was incomplete.
Incomplete.
That is, does not say that there is no collateral.
Lord, as I said, Lord, once the account becomes NPA, it's a clear indication that the borrower can't pay. And on that, a proceedings will have to be initiated. Bank has to wait for the purpose of ascertainment of the actual loss. Unless the proceedings come to a culmination, Lord, the actual figure can't be, Lord, ascertained. This is, Lord, a procedural aspect of the matter which we have to follow. We have to go to the tribunal and file a proceedings for the purpose of recovery. But there is a deemed loss to the bank as on the date, Lord, when the accounts become NPA is well established.
Whether we can say deemed or potential loss.
Potential loss.
There
not
can't be a
deemed,
deemed
but
loss.
Potential.
There is a potential loss. It may not also ultimately become a loss. There are so many cases where recovery is done of all the
But
amounts.
recovery is by sale of assets.
Correct.
It's post decree that we get a chance to sell the assets and, Lord, recover. It's only then, Lord, actual loss has to be ascertained. It is a matter of time consuming factor. And at the same time, Lord, there is a time restrictions in so far as initiation of proceedings is concerned.
That is your regulation. Your regulation says quantification of.
Otherwise, Lord, there is no remedy so far as recovery of public money is concerned.
Even otherwise, despite all norms being followed, there are instances galore of accounts becoming NPA. It happens in the banking business every day.
Every day. It's not a new phenomenon.
Declaration ipso
But
facto cannot.
At least here, Lord, vigilance was able to find out that there was some irregularity in these accounts, and all the 7 accounts which were dealt with by him were found to be, Lord, irregular. The NPA declaration was in respect of all.
That was a preliminary inquiry leading to issuance of the charge memo.
And, Lord, he did not defend himself. It is not his case, Lord, that he defended himself, Lord, appeared before the inquiry officer, established that there were other accounts which is profitable or functioning.
One thing we want to know, when he objected that a proceeding now cannot be conducted under 48-49, did you respond to him that no, we don't accept your such an objection, we will continue with the proceedings anyway?
Lord, if your lordships, Lord, kindly take this objection was raised, Lord, in his reply to the charge sheet, page 56.
Yes.
This objection was raised. After that, Lord, we did not, Lord, stop the proceedings. We did not.
Did you tell him that we don't agree with your such objection? Did you reject such an objection by any communication? Because he is saying that your entire proceeding in effect is without jurisdiction. He refuses to submit to your jurisdiction. So did you tell him that no, we don't agree with this, you must come?
Lord, that page 59 onwards, the proceedings, the inquiry officer, he kept on serving him notice, asking him to appear. Okay. 159 is the letter of 17th May 2006. Then, Lord, that day he did not appear. And then the next date was fixed. The next date, Lord, also he did not appear.
Yes, it goes on till 12/7/2006.
Yes. And, Lord, each minute, Lord, is recorded that he is not present. And the case is that, Lord, in the same address, he does not accept, Lord, the order communicating the punishment. But, Lord, all this, the show cause notice he receives, he answers. He receives, Lord, the charge sheet, he answers. And then, Lord, proceedings, he doesn't appear.
Yes.
Lord, the judgment that my learned friend has cited has no semblance of, Lord, factual resemblance, Lord, so far as our case is concerned. Here is a case, Lord, on initiation, there were certain facts on which the initiation took place. Then, Lord, he replied, he initially participated, after that he just stopped participating. And, Lord, the fact remains that he did not challenge it for 10 years. That was not the case there. For 10 years, he remained silent. He accepted, Lord, the order of penalty, and he did not, Lord, challenge it at all. Then one morning he woke up and he thought that he can file a proceedings. And your lordships will not find that there is any explanation with regard to And nowadays judge doesn't deal with the question of delay. At least he was aware of the fact that initiation of proceedings have happened. He could have inquired, he could have written a letter to the inquiry officer explaining his difficulties. Or he could have said that unless that point is answered, I will not participate. Look, these are my submissions, Lord. I'm grateful for a very patient hearing.
Are the parties?
Number 24.
Shani Roy Chaudhary is appearing for the appellant, but due to certain details of her uncle, she could not come today, Lordship. I am praying for 1 day accommodation, 1 week accommodation.
1 week. As prayed, list after 1 week.
Item 25.
My lord, I am for the writ petitioner appellant, my lord. My lord, in writ application, my lord, we have succeeded, my lord. Very limited, on limited point, we have preferred this appeal, my lord. Now
is
we have-
limited.
My lord, limited. My lord, disciplinary proceeding, appellate authority, then learned single judge, my lord. Because, my lord, the benefits, my service benefits were not granted, my lord. Although, my lord, disciplinary authorities and appellate court, appellate authorities order has been set aside by this learned trial judge, my lord. Now they have award, my lord, there was one application, can two, my lord, that is section 5 application that was allowed by your lordship, my lord. Now on last occasion, my lord, they have submitted, my lord, they have also challenged this order, my lord.
Yes.
Now the problem is
Committee
that
54.
yes, my lord, 54, Act 54 of 2016, my lord. The problem is that, my lord, they have not served us with the memorandum of appeal or any connected applications, my lord. Well, kindly direct them to.
Is it listed today with this matter?
Yes, my lord, that is listed, my lord, because in terms of my lord's order, my lord.
Give a copy, give a copy.
My lord,
Can you make pass a formal order?
give us 2 to 3 weeks time to give.
For serving a copy.
Yes, ma'am. Grateful, ma'am.
Item 26.
26, my lord, I am for the private respondent deed petition.
Lordship, there is some defect in the filing of the case. There are six matters. So I may be allowed to remove the defects, and I don't have some delays. So I may be allowed to take the steps in the proper manner.
Group 6 appeal.
Group 6 appeal, my lord, it is with regarding to the rounding of 169.5 centimeter to 170 centimeter. Your lordship has already dealt with.
You learned.
Same.
My lord, item number 26, there is a condonation of delay application and the stay application, both. Item number 27 also same. Item number 28 also same. My lord, I think that
You are appearing in all. So 26 to 28, same order. Give your appearances.
Yes.
Yes.
My lord, I think the defect has been removed by filing this application. My lord,
Already.
yes, my lord, as because the application has already been filed, it is within the record. If the defect is with regard to the filing of condonation of delay.
In all these matters.
Yes. Not all these matters, my lord, item number 26, 27, 28.
Give the file of 26. He is saying he has not filed.
39, 40 and 41. হ্যাঁ এই তো আছে তো all are with application are there
26 application hai condonation
in 26 application can 1 and can 2 is
yes it is there
my lord, may I my lord, find out why the defect has been indicated by the stamp vendor.
Just let us see. 22 126 defective out of time. How many days did it? 69 days.
In item number 27, delay has been mentioned of 100 days. I think
26 MAT 104 is 26.
Yes, 10, yes.
The condonation has already been filed.
Oh, then I'm not instructed by my junior. তুমি ইন্টিমেট করলে না কেন ফাইল আছে কপিটা কোথায়?
Yes.
Lordship may fix another day. I will be prepared.
What fix? All these matters are disposed of.
Already not today.
What fix?
My lord, I have already the advocate on the court. I have already
Lord,
sent.
I'm no brief
both
at
the
this
orders.
time. I've not got my brief.
What is why it should be kept pending? It's pointless.
My lord, excuse me, my lord. I have one copy, my lord.
The first case there is a delay of how many days?
Here mentioned in application 100 days.
No, so therefore it is more than what is reported. Then there is no problem. Reported is 69.
Here mentioned is in application 100 days has been mentioned. And single petitioner, my lord.
And what about the next case?
Next case is, my lord, 100 days. Delay has been 105 days.
No report. Same 6900 same.
100.
So same. It is the same. No difference.
They are also saying single petitioner.
28,
28 my lord, applications are there.
82 days there.
82.
Max T24.
They are mentioning is 112 days in application.
So instead of 69, it will be 82. And instead of 100, it will be?
82 days.
No, in the application, you have mentioned how many days?
112 days.
112 instead of 100, 112. Which other matter? 31,
30.
30. Call 30. You are in 29.
If I am in 29, Your Lordship.
Please wait 2 minutes.
Here in application, the 190 days has been mentioned.
106 days. As per the record.
Oh, record, yes.
Record is as per the office report.
Yes, that's all.
Instead of 69, in this case,
Petitioner, it should be petitioners. Read petitioners.
in this 30
Yeah,
petitioners,
more than
plural,
one petitioner, it has three.
plural. Yes.
Obliged.
Yes, you are for the appellant in 29.
Your Lordship, in item 29, I am for the appellant. Item 29 and 45 are similar matters. It may be taken up tomorrow, Your Lordship.
All right, not to.
2 minutes are left.
All right.
Line 40 and 41.
One by one, keep the files.
I am apology for that.
You are appearing in all.
Here, my lord, 169 days has been mentioned in the section 5 application.
In 172. supplied in this case. Certified copy of the impugned order was not supplied.
My lord, it is with regard to the certified copy with regard to the item number 30.
No, no.
The same petitioners are there.
No,
My lord,
no.
item number 41 and 30 is the
Right now, we are
respondent.
considering MAT 785.
Yes, 785.
In this case, there is no report regarding the delay or anything because
It is within time, my lord, sorry, my lord, it is has been perfect. There is no mentioning of any defects in this case. Application is
no, there is
there
no
for them.
report because it would be furnished on receipt of the certified copy.
Lordship, earlier, the different team was there, they applied for certified copy, after that, we had engaged in this matter.
So what will you do? Tell us.
Lordship, we will take steps.
Give the certified copy so we can.
May I submit? My lord, this appeal has been filed twice. My lord, item number 30 is the same order, same.
Whatever it is, once that certified copy is there, we can pass the order. Otherwise,
Much obliged, much obliged.
the learned advocate for the applicant